Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-5069 et al. James Blassingame and Sidney Hamby versus Donald J. Trump, appellant. Mr. Binal for the appellant, Mr. Sellers for the appellee.
Good morning, counsel. Mr. Binal, please proceed when you're ready.
Good morning, and may it please the court. Jesse Binal, on behalf of Donald J. Trump. I will endeavor to save 2 minutes for rebuttal. The district court acknowledged that when President Trump made his address on the ellipse on January 6, 2021, he was speaking on matters of public concern. It also held that speech is unquestionably a critical function of the presidency. It even found that a first-term president is, in a sense, always a candidate for office. Nevertheless, the district court incorrectly held that the speech and other similar presidential communications were not protected by absolute immunity because the content of the speech had an electoral purpose rather than a governance purpose. This purpose-driven analysis that was favored by the district court is effectively a rebranding of the motive-driven analysis that was considered and soundly rejected by the Supreme Court in Nixon versus Fitzgerald.
I'm not sure that's fair. The district court just looked at the words on their face, looked at the speech and said, is this political or is this governmental, without getting into what was in the president's mind. Why is that? I mean, it might be right or wrong. It just doesn't seem to me motive-based.
Your Honor, the reason that it is because when you look at purpose and when you look at motive, those are words that are used interchangeably in the Fitzgerald opinion, effectively interchangeably in the Fitzgerald opinion, and goes to what the intent of the president is for a particular communication. And when you start to do that sort of functional surgery, when you get so far down in deciding, well, what really is it that the president is trying to do here? At that point, you start to blend the lines between what is something that is clearly within the realm of the presidency under Article 2 and what it's appropriate for Article 3 to look at. And that's why the Supreme Court was so clear in the United States, in the case of United States versus, Nixon versus Fitzgerald, that you have to have very bright lines. Because as soon as you start saying, well, the goal here really wasn't governance per se, but it was something that was political per se. It was to help him get re-election per se. As the district court even acknowledged in this case, with every first-term president being a candidate for re-election, it will become the exception that swallows the rule.
So I'm not sure line drawing cuts decidedly in favor of one side or the other. I think everybody has some line drawing issues here to some extent. And let me just explore that a little bit if I could.
Yeah.
Suppose you have a circumstance in which a president has a private meeting with supporters and urges them, and this is in advance of an election, and urges them to go to the polls in unfavorable areas to intimidate voters and prevent them from exercising the franchise. And then there's a civil action that's filed by someone who's been intimidated and deterred from voting under 1985, which I think it encompasses this kind of conduct. And the president asserts official immunity.
And by far, that would be a horrible situation that we would hope would never happen. But in a case like that, and what the Fitzgerald court was very clear on, it's not that there's not a remedy. The question here is only on civil liability versus accountability. There still is the opportunity for accountability.
So your answer is that in that situation, there'd be official immunity?
There would be official immunity, but
so even if it's a totally private conversation, and it's a private conversation between a president and supporters, and he urges them in private. What I'm worried about is winning re-election. All I care about is winning re-election. Doesn't have anything to do with any policy agenda. It just has to do with, I want to be president, and I want you to help me make that happen by going to the polls in areas in which voters are likely to vote against me and prevent them from voting.
A truly horrible situation if that were to happen. I want to make that clear. But in that case, the question is not necessarily whether it is political or electoral, but whether it is still something of public concern or, as the Clinton court said, only of private concern. And in that case,
well, I think what the Nixon court said was it's within the outer perimeter of official responsibility, and
yes,
that's the language that we're all
yes,
revolving our questions around. And so you think it's within official responsibility to urge supporters to prevent people from voting?
I think that's a disgusting goal, but I think that I think that's well within the realm of what the Fitzgerald dissenters used in their parades of horribles about how bad this could happen, what could happen if this goes wrong, and what the Fitzgerald court said. We understand that sometimes, even in the most extreme of circumstances, there are rights without remedies, and we do that with immunity every day. In this
what is the official responsibility that's being furthered there?
In this case,
in the hypothetical,
in the hypothetical, it's of course in something as bad as that. You don't want to say that there was something clearly on point the president could point to, but a president taking actions regarding elections. And I don't think you want to filter down any more than that, because once you filter down any more than that, then you get into this type of judicial oversight of the executive that was not envisioned by the founders. So the executive being part of elections, of the bully pulpit of the presidency, even if it's something that's only privately said to the supporters, to advance that. And I agree, Your Honor, that is
but the only thing that's being advanced in that hypothetical is re-election. That's it. And what's the official responsibility?
You cannot separate governance from election. If the president wants re-election, it's so that president can continue to govern. And so because of that, that's, I think, as far down as you can go to see that if this is within the realm of the presidency, as bad as that particular act might be. And I want to make it clear, that's something where you would have an extremely strong case for impeachment in the House, conviction in the Senate, and then you have the impeachment judgment clause. The beauty of this is that the founders gave us this system. They said that in certain circumstances, they know that something could go horribly wrong and that a president needs to be taken out of office. And if he is, at that point, he can be prosecuted for it. And something like that.
Impeachment isn't always the answer, right? Because, I mean, even you acknowledge in your briefs that there are certain things that a president does while in office that wouldn't be subject to immunity. You had some, I think sexual assault was one of them that comes up I think
the Clinton case was clear on that.
And so you could have an impeachment proceeding based on that if it's conduct while in office.
That's right.
And if impeachment, a conviction didn't happen after impeachment, you'd still allow for a civil action. In other words, it wouldn't matter that there's the impeachment remedy and it turns out that impeachment was unsuccessful.
No, I would say it's more like concentric circles on something like that, where, of course, you can have impeachment based on private conduct, not just official conduct. And you can certainly have a lawsuit based on, as the Clinton court said, purely personal conduct, where you have something that's sexual assault, something purely of a purient interest, and especially, of course, with the Clinton case, it's also very clear because it's conduct that happened before the presidency, not during the presidency. And I think it's particularly important.
No, I was hypothesizing one. I didn't understand your brief when you talked about sexual assault to be limiting it to sexual assault before the presidency. I assume you cover sexual assault,
yes,
even if it's coterminous with the presidency.
Yes, it's something like that is purely of a purient interest. So for the sexual assault, if it was, if it was a president talking to his stockbroker about his individual stocks, for instance, something that was only of his financial interest himself, not worried about the broader economy, but only the financial interest himself. That would be another example of something that is, as the Clinton court put, purely personal. And so if you have something that's purely personal, that's different.
Even if it's a speech. So on the purely personal one that you just highlighted, which is personal financial interest, if the president gives public remarks that say, buy my family's product, buy my son's product instead of the competitor product because the CEO of the competitor's company is a name your immoral conduct that's going to dissuade somebody from purchasing it. And the only thing that's going on is personal financial interest. Even if it's in a speech, you'd think that would not be immune.
That hypothetical is, I think, a much closer case because it could very well be that, buy my product because the other side is bad could very well be a public concern. But if it was buy my product because I want more money in my account, and it was really limited to that, if it was that narrow, then yes.
And how do you know that? So don't you have to mind motives to some extent, as you started out saying, to decide when the president says, buy my son's product.
Yeah.
And I really want you to buy my son's product. And part of the reason you should buy my son's product is because the person who sells the other product is a philanderer. It doesn't have anything to do with
a much closer case in something like that. And the other person being a philanderer, I think probably takes it to the point where it could very well be something that the public concern because it had to do with society's mores rather than just private concern. But that is a much different case, and it is clear that in order to decide if it's something purely personal, in the words of the Clinton court, you have to look at the act to decide that. But what you can't do is dive so far down that you run directly afoul of what the Fitzgerald court said. And it's, I think, noteworthy that in this case, the district court claims to be looking primarily at the Clinton case. But really, if you look at it, it's paralleling the objections of the dissenters in Fitzgerald. And so that really is the difference there, is are we taking and are we looking at a communication or presidential act so granularly that if you get far enough down into the weeds, you can certainly find an objection about, well, this is really personal, it's not presidential. But once you do that, you start this Article 3 oversight of the executive that is directly opposite of what the Fitzgerald court was looking at.
When the president gets involved in electoral counting, what enumerated power of Article 2 is he acting under?
Your Honor, while it's very possible that when the president is campaigning, he might be executing his article.
Let's focus on electoral counting.
I'm sorry,
on counting of electoral votes. Because normally, normally, the president has a take care power, which encompasses all federal statutes. He is a lawmaker to the extent he can sign or veto bills. So if he's talking about things that could be the subject of a federal statute, but that's sort of easy to see. The speech about the matter is sort of necessary and proper or closely connected to those powers. But electoral counting seems different because the Constitution and the statutes are very clear in excluding the president. So what power is he acting under?
And the words here are important because the Fitzgerald court doesn't use the word power or duty necessarily.
It uses the word function.
It uses the word function. So it's something that's not necessarily something that comes directly from a statute or constitution, but it does fall within the presidency.
So is that a vehicle for creating an unenumerated power in the president?
No, it's not something that creates unenumerated powers. But what it does do is...
Then which power is he acting under?
It's something that the part of the historical aspect of the presidency that's been long recognized is the bully pulpit, is the president to speak on things that are not necessarily within his official constitution or Article 2 power. So, for instance, it is very, very normal for presidents to comment on decisions of courts now. It has happened many times this year alone. It's very normal for a president to comment on any number of things that the president was specifically excluded under from under the Constitution. A veto override, the president would still speak on, even though he has no part in a veto override. There's any number of things that is normal and customary for a president to speak about, using the bullet pulpit, using those matters of public concern. And in these times, it's especially important that we protect the ability of the president to act, in the words of the Nixon court, with the maximum ability to deal fearlessly and impartially with the duties of his office. And so that goes, just beyond, and the Fitzgerald court talks about, you can't draw lines that are so fine that it ignores the history of the presidency and what the president does.
Even you haven't cited a Supreme Court decision that quite goes as far as your last proposition, you are asking this court to adopt that standard. In other words, you resist any effort to drill down, in your words. Yet, what I hear you saying, and I thought you were arguing this in your brief as well, that at least it's the bully pulpit, because that's just traditional, a part of a president's function, whether he is commenting on the actions of another branch or not, that the court has no role to play here.
Your Honor, if it's something, I would say that if it is something on public concern, that's right. At that point, the remedy is different than a damages action on the civil side of the court. At that side, then we have to follow the other remedies that are available, something that the Fitzgerald court was very, very clear about. In the Fitzgerald court, I think, goes into some detail about the 75,000 other, at that time it's probably more than now, 75,000 other people in the country that have protections of absolute immunity. And that doesn't mean that there aren't very worthy plaintiffs that are denied a remedy because of that. If you look at the remedy.
That's really your point. It's that historically, separation of powers, the founders made certain choices. And to the extent those choices were, what I'll say, rational decisions based on their experience in dealing with the king, that there may be gaps in our system such that, for example, the president may have no role in ensuring the electoral integrity of the process for electing president. But nevertheless, that is within the outer limits. And as I hear you, and I thought this is true in your brief, you really resisted any definition of limits. And I know the Supreme Court has spoken in terms of, well, when you can't cite an enumerated power or authority, then you can, of course, rely on history. But the court there seems to be focusing on 200 years of precedent, for example, in subpoenas of presidents. So I just wondered how you would have the court write the standard.
Thank you, Judge Rogers. And it's of course important to have standards like that. And the standard that the court should adopt is very similar to what was already done with Fitzgerald, in that you're limited to only seeing whether something is either within a statutory framework for the presidency, constitutional framework of the presidency, or historical framework of the presidency. And if it falls within that, that is the end of the inquiry for absolute immunity purposes, especially for for the presidency, where there's that, it's perhaps the most important absolute immunity of numerous in our system, because it's so inherent in the separation of powers. And so at that point, once you decide it's on issues of public concern, there still is an opportunity for accountability. It's just not accountability through a civil damages lawsuit.
Suppose I agree with you on speech of matters of public concern. And I also agree with you that it is too fraught to, as a general matter, to try to distinguish political speech from official speech as to the president. What makes this a hard case for me, is putting all of that aside, is the at least colorable case of incitement. And what is the functional justification or historical pedigree for extending an absolute immunity in the actual case or a hypothetical case to a president who just incites lawless action, riots in the streets, and so on?
And Judge Katsas, that's exactly the issue that I think the Fitzgerald court was dealing with when they looked at the arguments about what is the point of allowing a president to do something that is directly unlawful in a personnel.
No, it's very different. Fitzgerald was about a clearly official act within the president's power that might or might not be unlawful depending on the president's motive. Right? It's a retaliation case, and the court says that's just too intrusive to try to police that line. This seems to me different. You take the hypothetical case. The president gets out the microphone and says, "This election was stolen. They are not going to do anything. You go burn Congress down." Hypothetical case.
Of course, not with setting the speech, but hypothetically, in a case like that,
extend immunity, absolute immunity for that?
Only as in regards to civil liability. And let's look at something that's very, very horrible, and that is a prosecutor purposely taking and manufacturing evidence to put an innocent defendant behind bars, something that is absolutely horrible. And we still say you can't sue that prosecutor. It doesn't mean that that prosecutor is free from accountability. It just means that we say that that defendant cannot, the criminal defendant cannot be a civil plaintiff against that prosecutor. So
because we sort of expect that if we allow claims like that, they'll happen all the time. They might turn on motives. Just the burden on the system will be too great. So we just allow that wrong to go uncorrected through civil remedies. This just seems, I mean, how many cases will there be with a colorable claim of incitement against the president?
There might be.
And what's the harm of trying to police? You know, is this just above the Brandenburg line or just below the Brandenburg line? Seems like that is not going to hamstring the president in his day-to-day job.
I believe it is going to hamstring the president in his day-to-day job. And here's why: is because once you start to draw that line and you start to do a type of Brandenburg type First Amendment analysis of incitement in the presidency, at that point you now have judges that are acting on umpires on what crosses that line and what doesn't, in such a way that presidents will have to worry about giving speeches and everything, giving impassioned speeches, as every president has, and highly controversial speeches by presidents, which have happened before President Trump, has happened after President Trump, and have to worry about what judge is this going to land in front of, what court is this going to land in front of, in such a way that I might have to go through the full aspects of litigation, which is exactly what immunity is supposed to protect against. And that line drawing here, if you do, runs directly afoul of what the Fitzgerald court was concerned about, where they knew that things would happen that would be controversial, and they knew that the founders gave us an option for that. They knew that there was a way for dealing with that. It just wasn't through civil damages.
We'll make sure
I'm fine.
you had a line of questioning. Okay. Can I follow up a little bit on what I thought was the main argument you were putting forward in your briefs, which is about the bully pulpit and speech making. But what I hear from you this morning is not necessarily about the bully pulpit and speech making, because it seems like your argument applies to purely private interactions. And so I don't know what work the speech making is doing. It seems like the line you're drawing now is purely personal versus matter of public concern, regardless of whether it's in a speech or in private. And am I missing something? Because suppose you have you have the personal product, promoting a personal product. Mm-hmm. Even in a speech, your point is that if it's just for driving one's personal wealth, that's purely personal. And the fact that it's the bully pulpit. The president uses the bully pulpit to say, buy this line of merchandise. It's going to be great for me and my family. But I'm sitting on the bully pulpit telling you this is the best stuff you've ever seen. Buy this. But you think that because it's purely personal, the bully pulpit doesn't matter. It really, the dividing line is between purely personal and something that's beyond that, so as to bring it within official responsibility.
I think we come back to the lines finer than history would allow there, Judge Srinivasan, where the bully pulpit is incredibly important to this analysis. But the bully pulpit is something going all the way back, as far as what I've been able to look at and find, and I've looked at a great number of speeches at this point, is on these matters of public concern when you're speaking as the president. And that's the line that I think is particularly important to draw. I don't think I think it is difficult on any speech a president gives to decide that it's outside the bully pulpit of the presidency. And certainly the bully pulpit is within the outer perimeters of the presidency. But I'm just mindful of
but not no matter what it's about, because it's not, you don't have a bully pulpit uber alles rule, because even if it's the bully pulpit, if it's the bully pulpit about something that's personal, you think no immunity.
I'd say a bully pulpit on things that are personal only,
right,
is not historically as clearly historically as part of the presidency. I think that would be a very fact-intensive inquiry. I think that's very different in this case. But I think that is something that is a much closer call. But I would say that because...
But closer call, yes, but close enough that the lines have to be drawn so that even if it's bully pulpit and it's purely personal, however you define the category, so it's really, really personal, not just kind of personal. Again, I think I understand where you're going with this. But so long as it's really, really personal, even if it's the bully pulpit, no immunity. That's the way you look at it.
Here, and I think the words used in Clinton are right, purely personal. If it's something that's purely personal, the Supreme Court in Clinton says that's not due immunity. But that's very different than
if you have a presidential candidate who then says, an incumbent who's running for re-election, who says, I want to be re-elected, and the reason I want to be re-elected is because it's really good for me personally. My products are going to go through the roof if I get re-elected. That's what I'm worried about.
Admittedly, a much different case, and admittedly a much closer call. And private discussions are certainly a closer call, but private discussions are also just such an inherent part of the presidency. It's why we have executive privilege, of course, is because private communications are also a very important part of the presidency. And so the question then becomes, is this something that is within the outer perimeter, and part of the outer perimeter is speaking on matters of public concern? So if it's something where it's close. It's even close. And this isn't close. This is speaking about, if this is a speech about an election that is clearly political concern. This is dead center. But in the exception.
Go ahead, finish your story.
Thank you, Judge Ryder. But the analysis that you have is admittedly closer because it appears to be, purely personal at that point because it's only a pecuniary interest. And so you look at something that is, by the words alone, only a pecuniary interest, just like in the Clinton case of purely a sexual interest, then that makes it that very, very close call. But that's not where we are here.
So let me follow up on a couple of questions my colleague asked. Namely, had the president said, as I think Judge Katsas had a hypothetical, the election was stolen, and I want you, my supporters, to go to the Capitol and burn it down, or words to that effect. I want you to personally attack members of Congress. I want you to interrupt the proceedings. And what I'm trying to understand in your argument is where hypothetically the president is undermining by his words the system that the founders established, and arguably crossing the line to not only, maybe not specifically articulating burn the Capitol and attack members of Congress. Nevertheless, that was the reasonable import of his remarks as the district court found. And to the extent neither Nixon nor Clinton involved this type of situation where, to put it bluntly, even though the president may speak about destroying the constitutional system and doing so by crippling another branch of government, that's all within the outer limits of the bully pulpit, which at least heretofore I hadn't understood to stretch so far that it could be that type of remark.
And Judge Roberts, the hypothetical you use, of course, is different from encouraging your supporters to peacefully and patriotically make their voices heard. But I understand your concern and your hypothetical. And what I would again point you to is the Fitzgerald opinion, where they say that presidential matters will arouse, quote, arouse the most intense feelings. So this is not something that was unheard of to them. In a hypothetical like you just gave, you're looking at a very, very clear example when impeachment could be used. Go burn down the Capitol. Impeachment could be used. Conviction could be used, and very possibly at that point there could be, through the impeachment judgment clause, further proceeding.
What I think we're trying to explore is you're seeking absolute immunity, despite the nature of the remarks, and that impeachment is the only remedy. Isn't that correct?
It's correct that that's what the Fitzgerald court said that the remedy is. And so it's not what I think is appropriate or what's not. It's that this debate has already happened and it was decided by the Fitzgerald court.
What I'm trying to get is that we may not have 200 years precedent, all right, that the court looked at it Vance, for example. But there's always a first case. And certainly the district court and this court is not required to ignore the obvious unless there would be absolute immunity. And I think your argument is basically, it doesn't matter what the president says. He may arouse feelings. He may arouse feelings even where he knows people have come armed with military weapons. And any candidate knows there are fringe people supporting them. They have to be careful. But nevertheless, the complaint cites a course of conduct by the president over months. And is there no role at that point where, as the district court found, and these are not the district court's words, but the president is seeking to destroy our constitutional system?
And in the facts of this case, the answer is there is not a place in civil litigation to review those acts of the president. And any acts, no matter how
limits. That's my point under your argument. Even though you've couched some of your answers as well, we don't need to drill down any further. As a practical matter, regardless of what the president says, you're saying he is entitled to absolute immunity, and the only remedy under the Constitution is impeachment. And I'm just trying to get you to deal with, at least, I don't read the opinions of the Supreme Court to exploit that, although I understand the references to history, I understand the references to precedent, but there always has to be a first case, all right? And maybe it's not this case, and maybe it'll have to wait for the Supreme Court to identify that first case. But isn't that sort of the factual situation that's before this court?
Your Honor, the issue with the first case is that it will almost certainly open the flood doors to the 20th case and the 50th case. And so that is why we have to be, that's why the Fitzgerald court was so careful to close those doors on issues just like this. And what the court is wrestling here is certainly understandable, but it's the same exact thing that the Fitzgerald court wrestled with 40 years ago, and it made a decision on that. And if the argument is that the Fitzgerald court was just wrong, then that's a question for the Supreme Court, not for this court, because these are our questions as clear as Your Honor has been on the difficulties of presidential actions that arouse the most intense feelings. The Supreme Court has been very clear that that's not a position for courts, especially in civil litigation.
I just asked, no, go ahead, please.
You've said civil liability clearly off the table, impeachment clearly on the table. Do you have a position on criminal liability?
That's a very different case, but I think that I don't have to necessarily have a position on that because the founders did. And I think other courts have spoken more at length about it.
The attractiveness of absolute immunity in the civil context might depend on the number of other remedies available. So
that's right, Your Honor. I would agree with that. And so what you have is, I mean, for instance, we've talked about impeachment a lot today, but the Fitzgerald court talks about the other remedies.
Is criminal a possibility?
Criminal, if you look at other cases that are out there, theoretically could be, especially when you look at the impeachment judgment clause, where if in the hypothetical that the court used earlier, there was something so extreme as instructing people to burn down the Capitol,
right?
And something that inflaming, we're looking at a very, very different case than peacefully and patriotically make your voices heard, where at that point, the case for impeachment, for removal is so strong that you have the impeachment judgment clause for just that reason, where the founders made very clear that after an impeachment, after a conviction, after a removal from office, that there can be criminal aspects. You then also look at some of the other cases that have been decided more recently. You know, of course, you have United States versus Nixon, et cetera, where there could also theoretically be other remedies that are available. And the Fitzgerald court was extremely clear that they were only talking about civil liability. Well, they didn't go into as much detail about things like criminal liability, and that's not why we're here today. The Fitzgerald court was talking about civil liability. That's why we're here today.
Just two more questions. I know, and we'll give you some rebuttal time. What do I do with the following set of considerations? That for when a president is seeking re-election, there's a lot of things that a president might do to seek re-election that are nothing bound up in his official responsibilities as president, because the opponent might seek to do the very same things. And the opponent, by definition, can't be the president. We don't have to be presidents at the same time. So the opponent says, I want to do the following things to make sure that my side wins. And all they're trying to do is to get in office. The president's trying to do the exact same thing. Why isn't it the case that when you have actions that could equally be done for the exact same purpose, which is to gain office, that a non-president can do, it takes it outside the ken of what's within the perimeter of the president's official responsibility, which is the words that
yes, Judge Srinivasan, and there are certain advantages, of course, that are built into our system that an incumbent president does have. And I don't know that this is necessarily an advantage so much as it's something that follows the office of the president. And so, for instance, an early candidate for president is not going to have Secret Service protection, but a president is. A candidate for president is not necessarily going to have the amazing advantage of having Air Force One. A president is. And in this case, there are still very robust protections for all presidential candidates. The First Amendment, dead center, has to do with political speech and what a presidential candidate is going to say on the campaign trail.
I guess it's not what I'm asking about, and I know I'm asking it very abstractly, so I can make it more concrete, but I'm not trying to say that there's a disequilibrium and that one side is advantaged for purposes of the election. I'm not worried about that. What I'm worried about is whether it actually falls within official presidential responsibility when what's going on is campaigning for office. Both sides are campaigning for office. Both sides do things that try to maximize the chances that they'll win. It just turns out that when the president does some things that maximize the chances that he'll win, it's immune. When the other side does the exact same thing, the other side, to use the hypo I started out with, tries to get people to the polls who support them to prevent anybody from voting in districts that are going to be disadvantageous for them to have a high vote count. And all they're trying to do is get in office. Doesn't have anything, by definition, has nothing to do with official presidential responsibility, because all they're trying to do is get in office. It's the exact same thing the president's trying to do. All he's trying to do is trying to get in office. But yet, total immunity on one hand, you can have agreements with people to go to the polls to stop people from voting, and you can't be sued civilly for it.
That's right, Your Honor. And I understand what the court is concerned about there, but what I would say is there may be a number of things that are within the functions of the presidency that are not unique to the presidency. So while it is unique to the presidency that he has, at least highly unusual to the presidency, and probably unique of the bully pulpit of the presidency, it certainly is not the case that other people can't give impassioned speeches that get a wide audience and that you're going to have different legal protections. It is still the case, for instance, that government employees that retaliate against other government employees are not going to have the same level of immunity. They'll have a different immunity. And there's certainly, of course, retribution in employment that happens all across this country every day. There's no immunity at all. So, and of course, in courtrooms just like this one, certainly in this building, you have people that are operating where a prosecutor can do one thing and be immune from civil liability, and a defense attorney can do almost the exact same thing and is very much subject to liability. So this is something that's inherent within our system, that because it's so important to protect certain functions of certain offices, that it's going to be that disequilibrium, at least to some extent.
Last question for me for now. The insulation that immunity affords would apply even if the president, who's a presidential candidate, offers payment, right? So the way you're looking at it. So if the presidential candidate says, I'll pay you to go to the polls to prevent people from voting. I'm not talking about speech. I'm just saying that's an action that just said, it's an action that says, I was intimidated from voting. I went to the polls to vote. I couldn't vote because this person came to me armed and said, you're not going to vote today. I went home. Turns out the president paid that person to make sure that I couldn't vote. Doesn't have anything to do with speech. It's just the conduct of preventing me from voting. And the conduct the president took. Your answer is still immunity.
My answer is that immunity civilly. Right. That is something dead center that there should be very serious consequences for in the other aspects of accountability. But as far as civil immunity goes,
even in a case where First Amendment law would treat something as a verbal act rather than as speech?
Yes, Judge Katsas, this is different than a
Why are you fighting
analysis.
That's not this case. Why do you need to win that?
I don't need to win that. I think that, of course, is a much, much closer case.
Well, I'm trying to understand.
That seems like an extraordinary.
No, that's an extraordinary. And I will say this. That becomes something that certainly is very fact dependent because it's not part of the bully pulpit of the presidency. It's something on matters of public.
But we already got past bully pulpit.
Right.
Well, I mean, I think earlier you realized we're past the bully pulpit because even private conversations are fine as long as they concern an election. And
certainly, yeah, immunity is not limited to the bully pulpit. Absolutely. And so what I'm getting at there is that it is certainly much harder to tie the hypothetical that you just gave into a historical aspect of a presidency, such as the bully pulpit. It's a much, much closer case at that point. So, for instance,
but still immunity under your view. I mean, your argument is that you have immunity because it has to do with an election. And that's
well, it's a closer call. I still think immunity probably would apply in that situation. But and one thing to look at is congressional immunity, where you might have one member of a House of Congress beat another with a cane, right? And that wasn't part of speech and debate. Because it was beating with a cane, there was criminal liability on that. And there was no protection on the House floor when that happened with Preston Brooks beating Sumter on the lead up to the Civil War. So something like that, where we look at the other immunity for Article 1, you can look at and see that there is a much closer case
right. And to fall within immunity, which you said it does, that means that conduct is within the outer perimeter of official responsibility. That's within official responsibility.
I'm saying that because it's, let me walk
it has to be. I think this has to be your answer.
It is.
Yeah.
It certainly is my answer that it is, but it becomes then the closer call that we talked about, not nearly as clear as we are here as to whether that's connected to something that's historically part of the presidency, unlike giving a presidential speech or communicating as president.
Okay. Just one more question for me, which is about an argument I don't think you made, but correct me if I'm wrong. The principal statute here applies generally to persons. And we in the Supreme Court have a line of cases which say if you have a generally worded statute that covers persons or agencies, right, in the FOIA context, the APA context, we presume that those general words don't pick up the president. Did you make that argument? And if not, why not?
I'm not sure that that's quite as with, let me say this. That is clearly something that the court should consider in a Nixon type analysis I think that the court certainly can make that a consideration in a Nixon versus Fitzgerald.
Did you make
analysis.
the argument?
I don't know if we made it in quite that way.
I didn't see it in the district court opinion.
I believe it was yeah, you know, Judge Katsas trying to go back to the briefs. I don't want to make a representation that I'm
Fair enough.
unclear
It
of.
wasn't before us. It just struck me that might be a little bit of a narrower and more textually based way of sort of operationalizing some of the themes you're articulating than getting into immunity, which has a little bit of a made up feel to me.
That's right. And
Well, to be clear, as I understand the question, it doesn't have to do with Nixon versus Fitzgerald immunity. It's that textually.
No, it's a textual. It's
Right.
a
That's
question
right.
whether
That's
whether that's open to us as an alternative.
I'd say it certainly is open to the court to decide something on that limited ground. And I'd have to think about the avoidance canon and whatnot, and whether that's an appropriate
Just in
way to
the
do it at this stage.
Immunity's a little bit open-ended. It might be common law-ish, but it might be Article 2-ish. So if we render an immunity holding, I suppose it depends on how we write it, but we could be saying something about the Constitution, which statutory theory would not.
That's right. And this gets into a little bit of a discussion in Fitzgerald, actually, between the majority and Chief Justice Berger, talking about what Congress can specifically do regarding making it so a president is specifically subject to suit. But I agree that would be one aspect of an avenue that the court could take to resolve this question.
Well, not our court. I mean, it's not, that issue's not before our court. You're just saying a court.
A court that could certainly be something that resolved it.
It's not part of the immunity question.
It really is not part of the immunity question. It's something that I would say is separate. And so that's something that could be looked at.
Make sure my colleagues don't have additional questions for you at this time. Thank you. Well, we'll give you some rebuttal time. We'll hear from Mr. Sellers now.
Good morning. May it please the court, Joseph Sellers. I do want to address the immunity issue. Before I do, I want to answer a question Judge Katz has just asked, although I think the issue of, I think it's the clear statement rule, is not an issue here because of the nature of the question presented. But I would just call to your attention the Franklin against Massachusetts Supreme Court decision at 505.
That's one I had in mind.
Okay. Well, the key there, the language there expressly says that it's the president's coverage in a statute, which it's not named, should not be presumed where it might interfere with the president's constitutional prerogatives. And I submit that here, the president has not been engaged in anything remotely like constitutional prerogatives. So while that statute might apply in other circumstances where the president has acted, in our view, outside the outer perimeter of the presidency, I don't think you can apply that rule here. And I think Franklin and courts interpreting it have so recognized. So let me turn to the question that we do have before us, which is President Trump is not entitled, excuse me, to the immunity which he seeks because his conduct interfered with the peaceful transfer of power, which is exclusively entrusted to Congress by the Constitution, in which the framers intentionally excluded the president from. And as a result, it's inconceivable that that kind of conduct, which infringed the prerogatives of another branch of government, can be within the legitimate duties of the presidency, even the outer perimeter of those legitimate duties. It would be extraordinary, and I'll come back to President Trump's proposed matters of public concern, although there may be less of that to discuss than before. But it's inconceivable that the president can avail himself of immunity, which derives directly from the same separation of powers underlying our government that his conduct thwarted by blocking the discharge of duties solely entrusted to Congress and from which the incumbent president was intentionally excluded. you can't have it both ways. He can't avail himself of an immunity provided by the separation of powers, and by virtue of conduct, it infringes on the separation of powers, and that is what he's done here. I can turn.
So let me just test that a little bit. So suppose the president exhorts people who he's speaking to go to Congress to stop a vote on legislation that he opposes.
So
that's interfering with Congress's conduct of a vote, but it's something the presidents often encourage people to let Congress know that they oppose legislation that's being considered.
I think the circumstances here are more extreme because this is a situation. There's no question that the boundaries between the branches of government are not always, they're not siloed. So there are occasions where one may be engaged with the other. But this is an area that's hermetically sealed from the presidency, in which it's clear that not only was it exclusively entrusted to the president, but as opposed to maybe people appearing to lobby or to express opinions on a piece of legislation. And very importantly, as Federalist Paper 68 states, was intended to keep the president, incumbent president, away from the very process he interfered with. So I don't think it's the same circumstance. I think this is one that is not your run-of-the-mill president saying, you might go to Congress and tell people that you don't like this legislation, which is maybe within the province of the.
What if the legislation is an amendment to the Electoral Count Act?
I'm sorry, it's an amendment to
if an amendment to the law that defines how Congress.
I still don't think that that's. I mean, if it's enacted, it may be a different matter, but I think it's.
No, but he opposes the legislation or supports it. Either way, he exhorts his.
I don't think it. I think we're talking about what's incorporated into the Constitution, and the Electoral Count Act is in aid of enforcing the terms of the provisions of Article 2, but it's not something that is part and parcel of that. So I would not. I don't think we would think that is the same kind of violation of separation of powers.
You think it is?
It is not.
It is not. So the president, that would be immune.
That would be immune. Yes.
There are lots of circumstances in which a president speaks on matters that aren't in any obvious way connected to his take care or bill signing or other enumerated powers. Your broadest theory would call all of that into question, or would at least expose the president to civil suits. That seems troubling.
Yeah.
So let's just talk about a couple. The president is hermetically sealed away from deciding cases or controversies within the meaning of Article 3. There is hypothetically a leaked draft Supreme Court opinion, and the president issues a public statement strongly supporting or condemning the presumed decision in a pending case.
Right. Again, I don't think it is. The bottom line is, I think the president's entitled to immunity. And
is entitled
to immunity. And
on what theory?
On the theory that
it's just talking about the result in the case.
Correct, and that's the reason I think he's entitled to immunity. The remarks I think that President Trump's standard that he's proposing here, which focuses on the speech, although I will come to the district court's, I think, well thought out characterization of the speeches as promoting his incumbency, but putting that to one side, as a general matter, I think the remarks the president makes are generally immune from
speech. It's on a matter of public concern.
Right.
And it's in an area where the president has no direct power to
understand. I think that what makes this particular situation an offense to the separation of powers is that his remarks were part of a ongoing course of conduct, which led to the actual disruption of the performance of
And
the student.
we'll talk about that. And just to show a few cards, what makes this a hard case for me, I asked your opponent about this, is the, I'll just say arguable or colorable incitement. But your broader theory about, if the president is talking about a court issue or a state issue or cultural issue in the world.
Oh, I think I'm sorry to interrupt you.
No,
I think those are ordinary functions of the presidency and would be well within the boundaries of the outer perimeter of the presidency is entitled to immunity.
So the Supreme Court says that Congress lacks constitutional authority to prohibit possession of weapons within X hundred feet of a school. President gets on TV and in fiery rhetoric urges the states to prohibit possession of guns within the school zone. That's fine.
Again, I don't think it's an offense to the separation of powers. It is a form of which there's a lot of fiery rhetoric now these days in public discourse. So that alone, I don't think is.
Sure, but I mean, I'm constructing the hypo so that you can't connect the speech to
it. But as I understand, the key part of the hypothetical is that he urges the states to take action, and it's that action which.
And then he goes on to say, you better do this because these gun manufacturers have blood on their hands and they don't care that school children are getting slaughtered. Right? It's very fiery.
Yes,
and it's not just they should act. It's they should act because there's some bad person doing something.
I understand. I think there's immunity there. His action, his remarks are urging the states or anyone else to take certain action. But the key part is that there was no interference there, as there was here, with the actions of a co-equal branch of government.
Okay, so hypothetical case, electoral counting, and the president gives the speech, urges people to march, and is crystal clear he wants a nonviolent protest. And he quotes Gandhi and Martin Luther King and asks the protesters to sit in front of Congress and be arrested.
Right. I don't think the focus from our perspective is on whether the consequence is the interference with, in this case, the electoral college count, ballot count. And if there's the interference with the core function of another branch of government, whether it is because he's told them to act peacefully and they nonetheless interfere, or he incites them to violence and they interfere. The key is that they interfered as part of his direction in a core function of another branch of government exclusively entrusted to their branch of government. And here, one that was the framers couldn't have been clearer that they wanted the president to stay out of.
So the answer, the answer to the hypo is that
I'm sorry if I didn't answer it.
There is immunity or there's not.
There is
crystal clear. He wants a peaceful protest.
There's immunity, at least if I understand your hypothetical correctly. There was no interference with the ultimate electoral college ballot count in your hypothetical. Am I correct, or did I misunderstand it?
Well, I'll give you two. First one is no interference. Crystal clear, no violence, peaceful protest.
Right. I think there's immunity.
Okay, same hypo, except, and just take this as a stipulation, unforeseeably to the president.
Right.
Some bad apples in the group.
Right.
Don't follow his direction to peacefully protest and break in.
So you raised the question, which I think is, I'm sorry, I just need to answer your question, is by saying that I think under those circumstances, to be direct, there's probably immunity, but I want to distinguish it from the circumstances here, if you'll permit me, because here there are, and I can review them from the record, events that occurred here that are not just, that show this was a continuous course of conduct by the president for which he is ultimately responsible, as opposed to the totally unforeseen circumstances, which I understand your hypothetical.
So I agree with how you're thinking about the case, which is to say the pressure point is the arguable incitement. That's a bit different from the district court theory, which is trying to draw a line between official speech qua president and speech qua
Sure.
candidate.
So let me turn to that, which the district court, I think, offers another and in some ways narrower ground on which to affirm, but it is less susceptible to any clear.
I actually think it's much broader. It's much broader, right, because the line between candidate speech and presidential speech is going to.
I totally agree with you. When I said narrower, what I meant was on the well-pleaded allegations of the complaint here, I think the district court's ruling can be affirmed. What I think even the district court acknowledges is that, excuse me, it's very hard to draw some lines based on that would guide future presidents.
Right.
Which is why I think we look to, as the benchmark, the separation of powers as a much more endurable and way of looking at this, and one that the Supreme Court in the Nixon case and the Clinton case both examined.
That's the narrow ground. When you say there's a narrow ground, that's the one you're talking about.
I'm sorry, what I mean by narrow is I perhaps should have said well-defined ground rather than narrow.
But that is the one.
I'm sorry, which is what?
I'm sorry.
If it's not a case-by-case judgment of whether the challenged speech is official or electoral, what is it?
It's instead the more general standard is whether it infringed, disrupted the separation of powers, infringes the co-equal branch of government in the discharge of duties exclusively entrusted to it. And the point, without characterizing it as narrow or broad, is it offers, I think, a clearer guide to future presidents and courts, and one that is entrenched based on the some of the jurisprudence admittedly limited from the Nixon and the Clinton case.
So if President Clinton, while the Supreme Court is considering Clinton versus Jones, exhorts people to go to the Supreme Court and let their voices be heard, to urge the court to rule in his favor.
To rule against, I'm sorry?
To rule in his favor in Clinton versus Jones, which is pending on the day of argument.
Well, it's pending. Yeah.
No immunity. Because there's separation of powers, it's interfering with the conduct of another branch.
If its effect is, it's not just about the purpose. If the effect is to, if they disrupt the functioning of the Supreme Court, if they stop the deliberations, if they do something of that sort, I think there's no immunity.
And whether it has that consequence is based on the allegations in the complaint. So the complaint alleges that President Clinton urged everybody to go to the Supreme Court to protest loudly. That ended up causing the court to take a recess while in the middle of argument, and therefore suppose that there's some injury that results from that, and civil liability, no immunity.
I see my time is expired.
We might keep you longer.
That's fine. I'm happy to be there. I just
Sure. Yeah, please. No, thanks for noting it, but absolutely.
Yeah. So I think under the circumstances you presented, again, I want to focus on whether the entire course of conduct that started with President Clinton urging the crowd to go to the Supreme Court would have been that the interference with the functioning of the court would have been part of the sort of inextricably bound up in his original direction or exhortation. So if he had said, go to the court and stand outside and chant, we want a certain outcome, and that was it, and some group nonetheless went and invaded the court, I think it is a harder call to divest him of immunity, because it is, under those circumstances, a part of a continuous course of conduct of which the end game, the interference, was not part of it. I can give you some examples in the complaint here, or in the record here, which I think show why this particular situation is part of a continuous course of conduct, which was.
But I thought a lot of the allegations are to the effect that the president knew what was going to happen. He kind of catalyzed what was going to happen. He didn't actually say, I don't think there's an allegation in the complaint that says,
Correct.
Go do what ended up happening.
Correct.
So there's always going to be this question of predictable consequences or foreseeable consequences, even if the words themselves, as alleged in the complaint, don't call for those consequences.
Right. But the circumstances here, if I can give you a few examples from the record that I think demonstrate that the President Trump here set this up with in order to interfere with the Electoral College ballot counting. So beside the fact that he called the assembled crowd to direct them to the Capitol, which, by the way, it was a violation of the permit, which only allowed them to stay at the ellipse. In dispatching the crowd to Congress, President Trump urged them to take back our country by demanding that Congress do the right thing and only count the electors who had been lawfully slated. He began these before January 6th, of course. He was repeatedly telling his followers about the election was stolen and stop the steal and it's fraudulent. So he set the stage on January 6th for a series of expectations about the legitimacy of the election. He then dispatched the crowd to go to the Congress. And as we also is alleged in the complaints, he chose the timing in such a way he could have waited till the Electoral College balloting had concluded. But he chose to do this at a time when Congress was actively engaged in the very process that he was exhorting the crowd to stop. And I think those circumstances make this evident from the record, without any need for discovery or anything like that. That was ultimately part of the overall course of action, which.
But it seems like a lot of that goes to degrees of likelihood that the injury would come about. And there's various data points that you've put together both here and in your complaint that say, should have known what was going to happen. And that's the same thing could be true when a president says, go to the Supreme Court.
Right.
And on that hypo, can I just ask the following question, which is at the outset, I think in response to Judge Katsas, if there's a leak of an opinion, but the opinion hasn't been issued yet by definition, so we don't know yet what the outcome of the case is going to be. If a president then urges supporters to voice their opposition to what appears to be where the Supreme Court's headed, what's the difference? And I think you said there would be immunity there. What's the difference between that and telling them to go there on the day of argument? It's still that the decision hasn't been rendered yet. It's still urging people to go and affect what the result's going to be. And it's still urging them to go and affect the result of a proceeding that's pending in another branch of government.
Right. And again, I think there's a difference in what I believe here was conveying the expectation that they would actually intrude on, stop the process for counting the Electoral College ballots. If in your hypothetical, it had been, and go into the Supreme Court and stop them from deliberating or something of that sort, I think we'd have a different situation because under those circumstances, they would be directly disrupting the functioning of a co-equal branch.
So then what's the standard? What's the standard you would say that we would write into an opinion that divides the kind of exhortation that infringes the separation of powers in the way that you think it's infringed here, and in situations that fall short because although the outcome happens and it sets in motion a chain of events that results in the outcome, you still have immunity?
I think based on the well-pleaded allegations of the complaint, that there was the president took action that disrupted or blocked the performance of a function, and I say blocked or disrupted because that term is critical to this as opposed to complaining or protesting or something, but actually disrupted the discharge of duties by a co-equal branch of government in an area that was exclusively entrusted to that branch of government.
But not that it had that result, because that's going to be the allegation in any case in which that result ensues. So what's the standard that it has to turn on what the president in fact said or did, right?
Yes.
Without regard to what result in fact came about. And
yes, but it's that he there is a. I think you have to evaluate it without having recognized what the result was. That is whether the president intended the result or not.
Right.
But so the first point is, did it have the effect of disrupting the discharge of duties exclusively entrusted to another branch of government? But in order to attribute that to the president, which would divest him of immunity, you have to look at, I think, excuse me, the entire course of events leading up to it, including events with respect to, for instance, what happened before January 6th, and look to see whether the president could reasonably be credited with responsibility for that series of events, all attributed to his remarks or his instigation. And admittedly, it's based on the allegation of complaint, as we know, although if immunity is denied, the president has an opportunity at the trial court with additional discovery to show that, in fact, that didn't happen the way that you've alleged, and I'm.
So I'm maybe my own density, so forgive me, but it may be my own density, so forgive me, but the standard would be then predicated on, it has to be predicated not on the actual outcome, on the effect. It has to be predicated, the standard by which we determine whether immunity exists has to be predicated on what the president said or did. And that standard, I heard block or interference. So is the standard the president asked for blocking or interferencing or interfering?
Either overtly, explicitly, or implicitly. That is, I think as you point out, the president, and I think this one was in our allegations was very artful in the way he did this, did not ever announce, go to Congress and stop this from happening.
But why doesn't that apply to the President Clinton hypo? The same thing. You could just say he stopped just short of it, knew what was going to happen. I'm just trying to get the exact words we would use.
Yeah, I'm sorry. If you can remind me of the particulars of your president, I have several.
Right. So Clinton versus Jones is pending before the Supreme Court.
Right.
The president says,
I see.
Okay. Go to the Supreme Court, make sure, protest at the court, and I need to win this case. And doesn't say interfere, doesn't say stop the court from doing what it's doing. Could be seen as just go and peacefully protest. Could also be seen as do something more. And that's the kind of ground that we have to be cognizant of if we were to fashion a standard along the lines of what you're saying. So that's why
and I guess I'm not sure I'm going to be as much help with this as you would like me to be, because I think it turns on the contours of the allegations in the case. So I think in your hypothetical, it's pretty thin compared to the circumstances we have here. And so I would say that instead of saying it's necessarily immune or necessarily not immune, I would say, again, I think the question is taking the record as a whole, is it plausible to infer that the president was initiating actions which were going to disrupt the performance of or block the performance of a co-equal branch of government's discharge of its duties?
Plausible to infer that the president was asking for.
I think that's all we can do on the face of a complaint.
And it wouldn't be plausible to infer that in the hypo in which the president says go to the Supreme Court.
I think it would be a closer call. I think it would probably be so thin, given the consequence, which is to waive immunity, that might fall in favor of granting immunity. But it is, I just think this has to be judged based on the plausible allegations in the complaint and the sufficiency of them as to whether they show an intention to, or not intention, but a president pursuing a course of conduct which is directed at disrupting the performance of a co-equal branch of government.
What is the relationship between this standard you've articulated, I'll just call it the blocking standard,
okay,
and the substantive First Amendment Brandenburg standard? So it seemed to me very odd to say that the president would lose his immunity for this kind of inciting activity in circumstances where a private party would have a substantive defense under Brandenburg.
Well, except that we hold presidents to a standard that they adhere to the Constitution, and the private party has rights in some ways that the president doesn't have.
So in your view, the president could be divested of immunity in circumstances where private party could not be held liable consistent with the First Amendment?
I think under the scenario you gave, that's definitely a possibility. I think here we have a situation which makes that.
Do you think the president on the merits has a First Amendment Brandenburg defense? I know the district court rejected it.
Yeah.
Do you think he has it?
I don't think as a member of the government that I think he has a First Amendment.
Even as an office holder speaking on matters of public concern?
I, again, don't think that the First Amendment governs that inquiry. But I would add one thing in this setting, in this case, that if the Brandenburg standard would apply, I think he crossed it.
So let's talk about that. That's, to me, that's where the rubber meets the road here.
Okay.
And it's a tough case. If you look at, you just print out the speech, which I have done, and read the words on the page, doesn't look like it would satisfy the standard, right? The worst parts of it are ambiguous terms, fight like hell, and there are other parts of it that are explicitly say, don't be violent. If you compare that to we're going to break your damn necks, which is Claiborne Hardware, or we're going to take to the effing streets, which is Hess.
Right.
This looks less inciting.
So first of all, I think this has to, the remarks on the ellipse on the 6th have to put in a broader context. This wasn't a speech that was delivered in a vacuum or in a blank slate. He had been building a series of expectations and skepticism and anger about the results of the election.
And if you minimize the words on the page and maximize the context, I'll just call, the powder keg, just use that for shorthand, then it looks maybe dangerous.
Well, and I would say that the fact that after rousing this group, which all responded to an invitation to the president that was laden with expressions about the election was stolen, it was fraudulent, and we have to make sure an illegitimate president isn't inaugurated, things of that sort. They come to the ellipse, and as I think the term you used, a powder keg, he created a powder keg by virtue of the lead up to that, and then he ignited it. And yes, there may be no single set of words at the ellipse that are tantamount to the kind of examples that you have in the Brandenburg cases, but taken as a whole, I think it's quite clear that the president was then igniting this situation talking about, again, demanding that Congress do the right thing and only count the electors who have been lawfully slated, and let's walk to the Capitol.
I get it. The Sixth Circuit has a couple of Brandenburg cases, including one involving a protester at a Trump rally who was roughed up, which seemed to stand for the proposition that if the words themselves are not very inciting and the primary danger comes from the powder keg, that's not enough to eliminate First Amendment protection under Brandenburg. You have a view on that? I mean, I know you have a view on that, but how should we? Yeah. How should we? I can't remember if these were in the briefs, but Bible believers and Nwanguma.
Yeah, I don't remember them being in the brief, but I accept your summary of them. So again, I want to back up for just a second, and I realize this may be very important to you, but I don't think the Brandenburg standard governs here. But that said, if it were to play a role in this, I think it's, and the Sixth Circuit concluded that the words are not enough, even if they're simply igniting a powder keg. I'd have to see the circumstances in which they said that. I think we have an enormous type of powder keg here. I'm not sure you could say one that's the case for all purposes, and I have to look at the Sixth Circuit decisions.
Well, one of them is there's a Muslim festival, and protesters go and right in the middle of it shout very offensive things about Islam and provokes a violent response, but the things shouted are clearly protected. And the argument for no First Amendment protection is like, my God, this was a powder keg. Of course, this was going to happen. Any idiot would know that there'd be a violent response. Well, and then the second case, Nwanguma, is it's a Trump rally. There are protesters. The crowd's getting worked up, right. And he says, "Get them out of here, but don't hurt them." So ambiguous words on the page, but fraught situation.
Right. So I'm not sure this is a perfect distinction, but one of the things I would say here is that beside the powder keg situation, I think here President Trump was launching a course of conduct that was, as opposed to perhaps calling some people by inflammatory names, for instance, or something of that sort. And I think that the distinction is important because it puts the president in a position to be part of the course of action that followed rather than simply an instigator. And not that I think he was an instigator here, but I think that is a distinction.
Okay. On Brandenburg, is it the case, I don't know the answer to this, do you get an immediate collateral order appeal in a Brandenburg situation normally?
Not that I know of.
So you could view Brandenburg as overlapping with presidential official immunity, but presidential official immunity also could be viewed as a distinct issue.
Yeah, and I think it's quite clear in the way the issue was presented by the appellant, and with which we did disagree because of the way it's framed, is I think the only issue that is granted immediate appeal is the issue of immunity. I submit that the Brandenburg issue is a separate important issue, but I don't think it fits in.
It could inform the content.
It was litigated below as a merits issue. I'm testing if I think it's a limiting principle on the immunity.
And I'm happy to answer your questions. I just
was trying to understand the architecture of the case. That's all.
I don't think it is squarely before the court right now.
It seems to me it's a novel issue because we don't have one way or another a case on absolute immunity in a borderline or just more than borderline incitement case.
Yeah, and so again, I agree.
So it could inform the content of immunity. I think it could, but I just was making sure that I understood where we stood in the case.
And it's one reason why we've been, again, returning to the separation of powers, because we think that's the benchmark with which to be viewing this. And the nature of the remarks may be part of the course of action that is there, but it's not, we don't see the First Amendment as interplaying with how the separation of powers allocates responsibilities between branches of government.
So can I ask you one question that is in this just general zone that's been giving me some pause, which is, does it matter if the statements that are at issue arise in response to a question from the press in a press conference, as opposed to a circumstance in which a president just chooses to make an affirmative statement or speech? And the reason I ask is you could obviously envision situations in which there's an elicitation of a response from a press question, and it seems eminently within the crosshairs of the president's official duties to have press conferences and respond to press inquiries. So he says the exact same thing,
right? But
it's in response to a direct question in a press conference.
I think there is a difference. And the reason it somewhat responded to Judge Katsas before is, one, where he has initiated this, I think it shows a degree of his responsibility for the continuing course of conduct, even if, in fact, in response to a reporter's question, he says.
So where you're going, I think, is that then literally the exact same words.
I understand.
Maybe apart from the lead-in. Immunity in response to a press question or press conference, no immunity when it's an affirmative speech. And I just want to make sure that's right. That may be what you're saying, but I want to make sure that's right.
I think what my intention was to say the response with the same content, the reporter's question, there's immunity.
So then in the affirmative statement situations that put it in the land of non-immunity under your rubric, suppose the president starts by saying, I know there's been a lot of questions out there about the following. He reads the Twitterverse, whatever. There's a lot of questions out there about the following. Here's my statement. Still, no immunity there because it wasn't literally in response to a press question in the middle of a press conference, even though the zeitgeist is.
Right. I think, did I interrupt you?
No, you didn't. Yeah.
I think the key question is whether you can infer from this that the president was intending to launch or initiate a course of action, the beginning of which is he starts with his statement, which you've referred to. And if that's the case, and there are, in this case, other circumstances that are consistent with that, I think he's responsible, and I think he loses his immunity. Even though he may have said something very similar or identical in response to a press question, at least.
But can't he intend to launch that same thing in response to a press question?
He could, if that's the way. If a reporter asks him something, he says, "I want to use this opportunity to."
So he doesn't say that, but he says the same thing. I mean, but the inference is kind of use that question as a vehicle for.
So again, these are going to be somewhat fact. I know this is not satisfying, but
but that's what we have to do.
Fact-driven kind of inquiries. And we come back to the point that the inquiry ought to be about whether the president, based on the well-pleaded allegations of the complaint, it's evident that he was launching or directing a course of action which is going to interfere with the co-equal branch of government.
And is it your view that then, as a categorical matter, when it's in response to a press question, that standard won't be satisfied?
If it's in response to a press question, that alone insulates it from is that what you're saying?
Yeah. Is it category? I heard your standard.
No, I'm sorry if I wasn't clear. I mean, ordinarily I would think it would be immune, but I would say if it is functionally equivalent to what I just said, the president launched a course of conduct, then I think he would have the same effect. He would lose his immunity.
Even in a press conference.
Correct. If it's a functional equivalence to standing there as if he said in response to the reporter, "Thank you for asking that question. It gives me the opportunity to announce that I want the crowd to go to Congress and do these other things." The fact that it responds to a press question, I don't think is
right. I mean, I don't think it's ever going to be that stark, but it would be, you get the question and you say, in the course of giving the response.
I understand,
it could be immune, could be not immune.
I think it depends on the circumstances, and I unfortunately think that's up to the courts. So
let me ask here. I understand the standard on summary judgment, but here I just want to be clear. You acknowledge, I think, that the statement, the actual words used by the president are not what the crowd actually did. In other words, the president didn't say break in, it didn't say assault members of Congress, assault Capitol Police, or anything like that. And what I'm concerned about is to what extent at this stage we're in a position that a court is in a position to give the plaintiffs the benefit of all reasonable inferences. And as I understand your argument, because of the president being the head of the executive branch, we expect certain types of conduct from him. And that conduct would not include denigrating the separation of powers. And so even though he was very careful in the words he used and had language in there that said, remember to be peaceful, nevertheless, part of our political system, as you know better than I, is there are always, unfortunately, going to be extremists on both sides who go too far. And the president says, I never told anybody to break in. I never told anybody to assault the Capitol Police. I never told anybody to rummage through the Capitol building. And a more negative inference, I suppose, arises because even after he was informed about the dangers that this crowd had placed members of Congress and had in fact disrupted the proceeding, and that people were being seriously injured, and there were direct threats toward the vice president, he did nothing to issue a calming statement and tell his followers, for example, go home, stop this kind of lawful protest that's become unlawful with people being injured, etc. So by standing silent, even when he did not know, arguably in advance, that some of his followers would take his remarks to be asking them to do what they were doing. Nevertheless, given the words he used, he is entitled to immunity because commenting that he thought over a course of time that the election was stolen from him can be viewed as a critique, a bully pulpit critique of the way the states were checking the votes that were cast and then certifying them to the Congress, and sort of trying to put the most negative inference on what the president was saying. One of the areas I'm concerned about is we have a history in this country of protests where they may start out as peaceful protests, but they turn violent either because of opposing points of view or police actions, etc. So here we're talking about the President of the United States, and he makes this statement after, as you say, a course of conduct. And then according to the complaint, even after he's told of the physical and human damage that has been done and is being done, he stands silent. So I guess my focus is that fact critical here, that is an allegation in the complaint?
Right. So Judge Rogers, let me try to respond to, you raised a number of very important points. First of all, to the last point you made, the allegations are in the complaint that in the afternoon after the crowd began to break into the Capitol, the media was covering this. The allegation is that President Trump saw the reports of that and not only didn't do anything to calm the crowd, he actually retweeted the remarks that he issued at the Ellipse to support them. There's also, even before that, when at the very end of the remarks at the Ellipse, when President Trump called upon the crowd to go to the Capitol, he started the allegations. This is a joint appendix, page 38. People were saying, shouting, "Storm the Capitol and take the Capitol right now." And the president did nothing to calm that or say, no, that's not what I meant. As to your point about there being buried within this lengthy set of remarks, a series of statements about go peacefully and patriotically, I think is one phrase that he used. Again, I want to make the point that this is part of a broader course of conduct, and it has to be looked at that way, not parsed separately with particular sentences, which I think would be a mistake in world courts and endless amounts of line drawing. Here, it was quite clear. He had a choice that he could, if he really wanted to raise the concerns about what he viewed was a fraudulent election or election security or something of that sort, he could have done that without dispatching the crowd to the Capitol at exactly the point when they were engaged in counting the Electoral College ballots. So this was sending a crowd to an area, as I said before, in which the Constitution is hermetically sealed this from the president and entrusted only to the Congress. And it is, I think, fair to infer from that that his intentions were to have this crowd attempt to interfere with that. In fact, he said, let's stop them from the counting the electors and have only those who are lawfully slated. An area that, again, Alexander Hamilton was clear in Federalist Paper 68 was to be excluded from the incumbent president. So I submit that your points are well taken. I agree with them. There is a broader point here, which is about looking at this as a continuous course of conduct.
Ask one more question. I want to make sure that Judge Rogers got a response. I'll ask one more question. You kind of framed this as two different ways to affirm in your mind. One is the blocking of the function of another branch, separation of powers rationale, and the other is seeking to vindicate a personal interest in attaining office as opposed to falling within official responsibility. For your argument, we haven't talked much about that one. And and they kind of merge to some extent, because one way to show that it's not part of the official responsibility of the president is if it's exclusively the responsibility of another branch. And I don't want to have an entirely new argument on this, but what's your reaction to the proposition that attaining office is vindicating one's personal interest in a way that renders immunity principles inapplicable because it doesn't have to do with something that's within your official responsibility?
Yes, it is clearly that's our position that seeking to perpetuate your incumbency or attaining office, as you put it, is necessarily outside the scope of the official duties of the presidency, because the presidency has no view as to who holds the presidency. So it cannot be construed as any kind of exercise, enumerated or otherwise, of any duties entrusted by the Constitution to the president. So it is my only reason to focus on the separation of powers is because, as I think the district court observed, it may be harder to provide some kind of, admittedly not perfect, but set of benchmarks to give the courts to administer this using the separation of powers as the ground position, as opposed to the question that was presented here. But I thought the district court did an excellent job of reviewing all the allegations and assembling them and digesting them and concluding that ultimately the president was engaged in efforts to campaign to perpetuate his incumbency on these factual allegations.
Okay. Make sure my colleagues don't have additional questions for you. Thank you, Mr. Sellers. Mr. Banal will give you 3 minutes for rebuttal. We'll see where that goes.
Thank you, Your Honor. Judge Srinivasan, as we started the argument today, one thing that the court brought up, and I understand the court's concern here, is that you said that there was line drawing issues on both sides. And I think we've seen that through the questioning today. One thing that I'd like to point out is that when there are these issues about line drawing and you look at the stark separation of powers concerns, the tie has to go to the runner, use the baseball analogy. You need to, and the Fitzgerald court makes...
And I assume you think the runner is the president.
The runner is the president in this case.
Okay.
And that much and more. The Fitzgerald court made so clear that even if it's close, that has to go to the president to protect that separation of powers interest. And the argument that my friend focused on about separation, the alleged offense to separation of powers, what that framework essentially looks at is that by saying that there's been an offense to the separation of powers that opens the floodgates, you don't necessarily have to worry about standing, you then can say immunity no longer applies. That's a particularly problematic analysis, especially since for separation of powers concerns, there is impeachment. A dispute between Article 1 and Article 2 is specifically provided for in the Constitution. Judge Katsas, one thing that I think important to look at regarding the court's Brandenburg thoughts is, well, it's certainly not the case that Brandenburg would comprise the outer perimeter, the full outer perimeter. It is important to see that speech by a president that is clearly within Brandenburg, as this speech was, as the court pointed out, you have to look at the words themselves, not the powder keg. And
that's my instinct, but give me your best shot on why, at least at a motion to dismiss stage on these facts, we shouldn't say that there's at least a litigable issue.
Because of the fact that immunity is meant to protect from litigation, not just from liability, but that is, as the Fitzgerald court points out quite clearly, as other courts in immunity.
I mean, this question is on the assumption that Brandenburg or not matters. And I understand your broader position is it doesn't matter. Just assume it does.
You only need the protections of the First Amendment when there is that powder keg, and a lot of times for incitement. So the powder keg is always there. It's certainly in there in the Clyburn case. It's certainly in there in Brandenburg, and certainly in the progeny. And so that's why it is so extremely important at that point that we then look at the words themselves. And in this point, because those words clearly fall within that, it must be that they're within the outer perimeters of the presidency, just as a matter of law, without needing further factual analysis, because that having to go through and do a further factual analysis at that point would eviscerate the entire purpose of immunity. I see my time has expired.
I have one question.
Yes.
Sorry to belabor this, but there's allegations in the complaint that are beyond the January 6th speech.
Yes.
And some of them don't naturally raise random questions or other kinds of questions. Some of them can be viewed as more private in nature, outside the can of what we've been talking about. So even if one thought that the January 6th speech is something that implicates presidential immunity, what about the fact that there's still other things in the complaint, like filing lawsuits in the personal capacity, like having private conversations with election officials in various states, like planning the rally, things of that nature that don't really squarely implicate a lot of the things we're talking about here, but that are in the case?
I think there's a reason why the district court effectively looks at this analysis as the communications, because those communications are the only thing that could survive the other aspects of the case. So, for instance, the district court, when it talked about the First Amendment analysis, acknowledged that the First Amendment would prohibit those other aspects of it. So that's why I think it's appropriate when we look at immunity here. Primarily, we look at the speech issues, but when you look at things like election lawsuits and other activities of a president, that still is within the outer perimeter regardless, but it's I think still very clearly a part of the outer perimeter test. And then you also come to the very particular problem if you want to, as the complaint suggests, go towards some sort of negative responsibility of the president. So, for instance, the suggestion in the complaint that the president had a duty to talk.
And that's not before us, because that I don't think that the plaintiffs lost on that and didn't appeal on the 1986 part. I mean, it's not, at least it's not part of the collateral order.
I agree. It's just as we're talking about the other things as part of the complaint, I would say that when you look at all that together, is this still something that the president is doing on matters of public concern? Is this still, beyond just the bully pulpit, the president doing as president? And he is, and anything else as the district court properly recognized would be prohibited by the First Amendment otherwise.
Okay. Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 21-1263 et al. Board of County Commissioners of Weld County, Colorado petitioner versus Environmental Protection Agency and Michael S. Reagan in his official capacity as administrator of the U.S. Environmental Protection Agency. Mr. Davis for the petitioners in case number 22-1013, Ms. Saint Romain for the respondents in case number 22-1013, Mr. Back for the interveners for the respondents in case number 22-1013, Mr. Shankman for the petitioner in case number 21-1263, Mr. Higgins for the respondents in case number 21-1263, Mr. Mahar for the interveners for the respondents in case number 21-1263.
Morning, Council. Mr. Davis, please proceed when you're ready.
Good morning, Your Honors, and may it please the Court. Bill Davis for the State of Texas and the Texas Commission on Environmental Quality, hoping to reserve 3 minutes for rebuttal. We present two challenges to the final rule. The first is that it's impermissibly retroactive, that it set an attainment date for El Paso County that passed before that county was first designated as a non-attainment area. The second is that EPA called its action a modification, but it could only have been a redesignation under text of the statute. And sorry, Your Honors.
Sorry, I'm just noticing I want to make sure that we have Judge Rogers with us technologically. Oh, sorry to stop you mid-sentence, but we'll just hold off for 1 second.
Sure.
I should have checked that before I started. Why don't we just pause for a second? We'll let you start over. We won't.
Certainly.
We won't have the clock running.
Wait the Court's instruction.
Appreciate it. Thank you. Sure.
No, I think it's working. It's back up. It's back up.
Okay. Mr. Davis, you're free to
Take it
recommence.
Or
Take it from the top if you wish. You have the full time.
okay. So Bill Davis for the State of Texas and the Texas Commission on Environmental Quality, hoping to reserve 3 minutes for rebuttal. We present two challenges to the final rule. First is that it's impermissibly retroactive in that it set an attainment date or deadline for El Paso County that passed before that county was first designated as a non-attainment area. And the second is that EPA called its action a modification. But under the text of the statute and this court's decision in Clean Wisconsin, the remand instructions there properly read, it could only be a redesignation. And under section 7511B1, a redesignation opens a prospective 3-year window for a marginal non-attainment area to reach attainment. So I'll start, if I could, with the retroactivity point. And just
So can I just ask you a question, and which relates to where you're going to start? It doesn't matter. Suppose that we think there's potentially something to either of those arguments. Is there some natural order by which we would consider them because one of them subsumes the other or one of them gives different relief than the other? Because as I roughly understand it, the consequence of concluding, as you urge, that what happened on remand was a redesignation rather than a modification, is that then there would be 3 years hence to attain, which is typically what happens with the redesignation. The consequence of retroactivity would roughly be the same thing, because your point is that you didn't get the 3 years if you put the attainment deadline before. Is there a natural order to this? Is there a reason that we would consider one before the other?
The court can take them in either order, and regardless of whether it agrees with one or both, the result is the same. The rule should be vacated, and there should be a redesignation that allows for that 3-year window.
So from your perspective, you don't care which way we go?
That's right. If the court prefers me to start with one place or another, otherwise I'll start with retroactivity and just say that EPA doesn't argue that it has power under either the APA or the Clean Air Act to regulate it retroactively in this context. It also doesn't say that the challenge part of the rule operates only respectively. Instead says that the attainment date that we're focused on is essentially inconsequential and that it regulated reasonably given the circumstances. But that attainment date is not inconsequential. It's a core feature of the Act's cooperative federalism, under which, as this court has recognized, EPA sets the standards, and then states have an opportunity to meet those standards. And here, Congress has said states get 3 years to try to attain.
So can I ask this question just to crystallize in my own mind, at least, where this retroactivity issue rises or falls? Suppose tomorrow EPA decides that even though the attainment date is the August 2021 one, and that the announcement of that date was after that date had already passed, we haven't determined yet whether you were in attainment as of that date. And suppose that the EPA decides tomorrow, actually, you're in attainment. Because we don't know yet that they won't do that. I think we can have some predictions, and I don't know the empirical data on this, but their point, at least part of their point, is we don't know yet. So they decide tomorrow you're in attainment. Is there still a retroactivity issue before us? Is there, what's the injury that you would have suffered at that
Sure.
time?
So the injury we're talking about is that elimination of, it's a procedural right that we have the 3 years. And so EPA has said, well, what you're talking about, reclassification, if we make that determination, that hasn't happened yet. They're right about that. What we're saying is that Congress gave the states that 3-year period, and we can see, and we cited some examples on page 7 of our reply brief, that states have taken advantage of that 3-year period and met that attainment goal within 3 years. And so it's not an empty right. And in fact, in Whitman versus American Trucking.
So even if EPA decided tomorrow, even if they decided today, even if they announced today at argument, it's actually just been a determination that you were in attainment as of the attainment deadline that passed, we should still rule in your favor and vacate the rule on retroactive grounds.
In our view, yes, because the rule is invalid on that basis, or because EPA tried to create a new modification power that the statute doesn't.
Suppose they did it in the order itself. Suppose they said the attainment deadline is passed. By the way, you were in attainment as of the attainment deadline.
So in that hypothetical, I'm not sure we would have the same injury to complain about.
Would you have any injury?
If the area were not designated non-attainment, and basically it would be the effect of the remand was to essentially confirm that El Paso was and continued to be an attainment area, I don't know that we would be here.
I know you wouldn't. You may not be here because you've suffered no harm, but I'm just trying to understand: would there be a violation of a retroactivity principle situation?
Yeah, it's an interesting hypothetical that I haven't fully thought through. I would say though, on this record.
Let me give you another one that's maybe I don't know if you would have thought through this one, but I just want to see if there's immediately leaps to your mind there would be a difference. Suppose EPA in the future suppose there's a situation in which EPA proceeds as you think they normally would, which is to give the 3 years to come into attainment after announcement. So they give the 3 years. At the end of the 3 years plus the 6 months that they have to actually make the classification, they say you are in attainment. Now, I'm just going to let you know, actually we measured attainment not by reference to the date that was 3 years ago. We measured attainment by reference to a date that was 6 years ago. You didn't know that. You had no reason to know that at all because you only knew about the 3-year date. You didn't know about what happened 6 years ago. But that's how we measured attainment. But you're in attainment. Would there be a that would be equally retroactive? Would there be a retroactivity claim?
I think EPA would have a much stronger argument because the retroactivity analysis is not a black and white proposition, as the court has recognized. And if the party that in that position could show no harm from it, I think it would be a harder argument to win a retroactivity case.
Then let me ask one last one, and then I know there's going to be other people that have questions, but I'll just continue this stream of consciousness riff for a second. Suppose then, what's wrong then with saying if it's possible that in these kinds of situations there wouldn't be a retroactivity challenge that would win, then what's wrong with, in this case, just waiting to see what EPA does?
Well,
what injury are you suffering in the interim while EPA waits to decide? And you may well have one. I just want to know what it is.
Right. So it's the procedural injury of not being able to do anything. Before this rule came down, August 3rd of 2021 was just any other Tuesday.
Mm-hmm.
And then after this rule, it's all of a sudden the date by which we would have been judged. And so that's just not how the Act operates. And if we waited until there's some further action against Texas, I would expect EPA to argue forfeiture as to this retroactivity argument.
Well, suppose we don't allow that. We're just going to hold the retroactivity challenge. We're going to insulate you from being procedurally barred from getting a retroactivity win at that point. I don't know exactly how we'll do that, but let's just suppose we will. Okay. What's wrong with that? And waiting to see what EPA does. If the EPA says you're in non-attainment, then boom, you've got your retroactivity argument. If EPA says you're in attainment, because you didn't have the 3 years to come into attainment.
Uh-huh.
If EPA says you're in attainment, so no harm, no foul, then even you've indicated that you're retroactive. You wouldn't even bring the retroactivity challenge in that instance. What's wrong with that?
Well, I suppose if the court is saying that we can bring the same challenge later,
or we just hold this present challenge until EPA makes a decision on whether you are in attainment.
I would say that the court should still rule in our favor here because, again, going back to Whitman, the Supreme Court identified Section 7511A1, which is the 3-year window, as the backbone of Subpart 2 of this part of the Clean Air Act. And allowing EPA to do this retroactive rulemaking just cuts the states out of that congressionally guaranteed window of time to attain. But if I could move to the modification piece.
Let me just, before you do, what's puzzling to me about this is I think the order is clearly retroactive in the sense that it creates a new exposure arising from past events, exposure. But we don't know whether that will cause any harm. I mean, you either did or didn't meet attainment as of the attainment date. That's just a fact about the past. There's no agency discretion. They have to decide that, and there's a formula by which they decide that. How do we? I don't know of any other retroactivity case. So if you focus on, will the exposure lead to a more concrete, it's a loaded word for standing purposes, but a further injury?
Well,
we don't know. If the question is just, does the order operate to change the past consequences, past events? The answer is yes.
Exactly. And that's the test for impermissible retroactivity. And I think one thing a state could have done differently is submit, as Texas has done, a 179B demonstration earlier, so that EPA would have had longer to consider that before the attainment date was coming up, or in this case, retroactive. But again, I think there are certainly states that have met that attainment deadline, and the way that EPA has approached this here just forecloses that result entirely.
But you still might. I mean, that's the tricky thing about this is you still might. And I'm not sure that just the language legal consequences doesn't necessarily, at least in my own mind, get a party all the way home on retroactivity, because in most situations in which there's legal consequences, there will have been some kind of detrimental reliance. There will have been something that the party can point to say, this is how we're harmed. And I know that there's also an injury component to standing. I get that. But I'm saying just in terms of retroactivity itself. And I think there's a forceful submission on your part that if EPA deems you to have been a non-attainment and you didn't have the time period to come into attainment because deadline passed before you even knew that this was a possibility, that seems like a retroactivity question, a serious one.
Yeah.
But if it turns out you actually were in attainment, then it's not clear to me. And as Judge Katsas points out, we just don't know the answer to that right now. The fact is baked, but we just don't know which way that cuts yet until EPA says something about it.
I think all that's correct. But again, in our view, we have a procedural injury. And maybe just to avoid repeating myself on that point, if I could offer maybe an analogy that could be helpful. Let's say that there's an employer who tells an underperforming employee on one day, you're underperforming, we're going to put you on a performance improvement plan. And there are two components to that plan. One is 4 weeks from now, we're going to reassess your performance, and you got to shape up. The second one is you have to fill out this form telling us what you're doing, what you plan to do. But in practice, the employer says, well, actually, you know what? That first part, we're going to evaluate your performance as of 4 weeks ago. But on the form, take some more time. You can get that in later. I don't think anyone would say, well, that's fair because, for one, what's this guy going to do? He's not going to change anything. Whether we, look at his performance 4 weeks ago or 4 weeks later, going to be the same result. And we gave him some more time for the form. I don't think anyone would say that's an okay way to treat an employee. And here we have, again, Congress saying that there is a prospective analogous provision to that Part 1 of the Performance Improvement Plan in my hypothetical. If I could, though, unless there are further questions on retroactivity, I'll move to modification because, as Your Honor noted at the outset, it's an independent way for us to win this case. And I think it's a clear example of EPA doing something that statute doesn't allow under the cover of this court's remand without vacatur. And I think this may be the most significant part of this case because remand without vacatur is controversial enough already. But if we take it beyond where it is now to a point where it's allowing agencies to do something that a statute doesn't allow, I think that's just a different level. And
if there was vacatur, would you think that what happened on remand would be a redesignation?
If there had been, so if the rule had been vacated in Wisconsin, there would have been the 3 years because EPA would have had to designate the area, right? And so because there was a remand without vacatur, it doesn't give EPA additional rights. It just moves the analysis from 7511A1 to 7511B1.
I mean, I guess to me, it seems it would be a little surprising if the panel that remanded thought that what they were remanding for is a redesignation, because a redesignation could happen anytime anyway.
Well, the court used that language. So the court used the language, revise the designations.
Right, not redesignation.
Well, no, but that language tracks redesignation. So in 7407D3, Congress used revised to.
But why remand? If they really thought redesignation, that can always happen.
Well, sure. I mean, what the court said in Wisconsin was there's a realistic possibility that EPA is able to substantiate these designations on remand. And so I don't think it was suggesting, any particular result, but the only path open to EPA was a redesignation. Modification is the province of 7407 D1B2. That applies when the agency or the administrator is modifying a governor's initial designation. But that has to happen.
Suppose
if we had vacated, why wouldn't the task on remand clearly have been a modification in the sense that the statutory sequence is, as I understand it, the governor makes a proposed designation, EPA modifies or not, so there's state action, federal agency action, and then there's judicial review. If we take the second of those off the books, the only thing that's there is the governor's proposal, and EPA is acting on that. And that is either acceptance or modification.
Right. So it's either promulgation or modification and promulgation as the governor's designation. Right. So either way, that's going to open for a marginal area a 3-year window for attainment.
I mean, this is a little bit of an odd case. We didn't vacate, but we did say that the modification under review was not yet legally supported.
Well,
right?
That's what EPA said.
We understood them to have been conceding that.
Right.
That was the basis for the remand.
It is unusual. I think the court pointed that out, that usually the agency will come up here and say, well, here's what's wrong with it. And the agency wouldn't even say that, which is why the court said there's a realistic chance they're going to do the same thing on remand. But if I could focus,
it makes it look more like they're finishing up the work they had done in the past than they did a chunk of work in the past that was fine, and now they're changing.
Sure, but we have to be guided by the text of the statute, right? The court can't. I don't think the court would say that it can order EPA to do something outside of the text. If I can point to section 7407 D1B4, that says that, so D1 B little Roman 4.
Okay.
That's a short provision in a sea of long provisions. And it says, when an area is designated, that designation shall remain in effect until it's redesignated. So when the court remands a designation without vacating it, that designation remains in effect until it's redesignated.
So you don't even think that if the original panel had the foresight to see through all this and understand the sequence of events and want to actually dictate what was going to happen, couldn't the original panel have said, we've got a petition for vacator. There's various collateral reasons for which we're not going to go to that extent to vacate, but we are remanding because EPA has acknowledged to us that its showing is insufficient. At least that's what we're construing EPA's motion for remand to be. But we want to make clear that when we're remanding, we're not saying there's going to be a redesignation if EPA switches and renders it non-attainment. That's going to be a modification, or that's going to be the original final designation. It's just going to be one that's dated later.
I think that would be an extraordinary thing for the court to do, because it would be saying, EPA, don't worry about what the statute says. Just go back and do this quickly outside of the modification.
So aren't we always outside the land of the statute in some of these situations? Because the statute also says that the agency has to accomplish the, I'm going to get my terminology mixed up, but they have to determine whether the area is an attainment or non-attainment within 2 years and then potentially one more year of the adoption of the NAAQS. And sometimes if you vacate and remand, it could be that happens well after 3 years. But we just assume that a court can do that because it's a part of what happens with judicial review.
Well, Your Honor's talking about a shall provision, something that EPA has to do. And so EPA can always be, the EPA always, or not always, but often misses deadlines. And it gets faced with citizen suits. And the citizen suit says shall, you have to do it now. I'm not talking about that with modification power. It's a may provision, right? The administrator may modify a governor's designation within a certain time. And so that's off the table at this point. And I think one of the cases that EPA relied upon here is Wild Earth Guardians. And I think that's an interesting case for this case in a few ways. One of the interesting parts of that case here, though, is that if the court had accepted the petitioner's view of what should have happened, it noted that that would have nullified the effect of another provision of the Act, Section 7513. And that was a reason to say, well, we're just stuck. We can't do anything that's going to fully comport with what Congress told EPA to do here. We don't have that situation here. EPA has not denied that it has the power to create side-by-side non-attainment areas and give the state of Texas its 3-year congressionally provided period. It just says, well, it's just not good policy to do it that way.
Can I ask this question? After the remand, if EPA had said attainment again, but they would have to supply more information to bolster that because we raised some questions about the explanation in the first instance, right? And so the basis for the remand was basically, we take you at your word that your submission was insufficient, your record was insufficient, and we're sending it back so that you can do some more and bolster that. So they do that and bolster it, and then they say, and we still find attainment. That would be the new designation, right?
I guess so. I think I might push back a little bit against that description of it, because as I understand Clean Wisconsin, it was EPA saying, we're just not going to defend this as is. It wasn't the court saying, this is deficient, go back and show your work some more.
But I thought what we said was, we're sending it back because we construe EPA's request for sending it or taking it back to be an admission that we didn't do enough.
Oh, okay. Yes.
I thought we said basically that.
I think that's. I think that is correct. And so I'm sorry, I misunderstood the direction of your question, Your Honor.
Yeah, and so then what EPA does is they take it back and they say, okay, the court has understood us to have not have done enough. We're going to do more, but we still reach the conclusion of attainment. So they come forward with a new. They have to do a new explanation. They come forward with a new explanation, and then that's then the relevant event for purposes of judicial review, not what they'd already done, even though they're re-ratifying an attainment. They're ratifying an attainment but with new explanations. So that's the new event.
Yeah, so in that circumstance, I would think the original designation it remains, and there's more support for that same designation, right?
But that more support, the date of the designation would be the new one, not the old one.
I would think it would actually be the old one, because the EPA would then just be supporting what it initially did. But
then how would there be judicial review of it? Because the limitations period would have passed.
Well, I would think that there would be continuing judicial review by virtue of remand. I guess I'm not certain.
I don't think we retain jurisdiction when we remand in this situation. So there has to be a petition for it. So
if what EPA did was come out with a new rule that under the Clean Air Act could be subject to a petition for review, then yes, that would be.
Wouldn't they have to? Because if they wanted to bolster their explanation, they'd come forward with a new rule that bolsters the explanation.
I suppose.
So then what I'm getting at is, if that's true, they're doing something new, but we still, under the way you're thinking of it, construe that as just redesignating as attainment, and not redesignating, designating again as attainment. Then why doesn't that also follow through to changing it to non-attainment? That it's still doing the same thing we did before, we're just doing that same thing again now.
Okay, so maybe I understand this. So in your hypothetical, there's no attainment date that's created by virtue of the attainment designation. So that clock doesn't start running. But if EPA comes back and does a redesignation or an initial designation, however it styles it, from that date, there is an attainment date under Section 7511A1. And that's what we're saying the states are entitled to.
I was trying to draw a distinction between the attainment deadline and whether it's a redesignation, because I think they may be It could be a necessary consequence of it being redesignation that you get the extra 3 years, but could it also be that you get the extra 3 years even if it's not a redesignation and it's just a redoing of the original designation?
Well, if it's a redoing of the initial designation, there wouldn't be that period in play because it was an attainment designation.
Okay.
Right.
Make sure there's no further questions at this time. Okay, thank you, Mr. Davis. Ms. St. Romain.
Good morning, Your Honors, and may it please the Court. My name is Alex St. Romain, and I'm here today on behalf of EPA. I'm joined at Council's table today by my colleague Elliot Higgins and Seth Bucksbaum of EPA. Per this Court's order, I'll be using half of the United States time to respond to Texas's arguments regarding El Paso's designation, and I'll be sharing 2 minutes of my time with David Bach, counsel for interveners supporting the El Paso designation. In Clean, Wisconsin, this court remanded 11 designations to EPA for reconsideration, directing EPA to complete the remands as expeditiously as practicable. On remand, EPA reconsidered its original designation for El Paso and determined that El Paso contributed to Doña Ana, New Mexico's non-attainment of the 2015 ozone NAAQS. Given that Doña Ana was already a properly designated non-attainment area with statutorily imposed effective and attainment dates, EPA determined that the best path forward was to revise the boundary of the pre-existing Doña Ana non-attainment area to include El Paso. In doing so, EPA treated El Paso consistently with its designations of all remanded areas and the way EPA generally designates contributing areas.
The agency action that designated El Paso as non-attainment happened in November 2020.
That's correct, Your Honor.
I mean, the status quo before that wasn't even that there was nothing in place. It was that there was precisely the opposite designation in place.
That's correct, because this court did not.
So the agency action that created non-attainment for El Paso backdated their attainment date by 3 years.
If the attainment date is August 3rd, 2021, and the rule is November, the rule came out in November of 2021.
Right.
But taking your point, I think the big picture point I'd like to make is that the attainment date does not, the past attainment date does not render the rule retroactive because there are no duties imposed upon Texas associated with the attainment date. So the only
there will be massive duties imposed if it turns out that they did not attain as of the past attainment date.
That is true, Your Honor. So
and your only response to that is, well, you haven't made that decision yet. That's not a discretionary decision. You're obligated to adjudicate a past fact about the world. They either attained or they didn't. And if they didn't attain, they have lots of regulatory burdens imposed on them.
that's true, Your Honor. I think I'd like to make 2 points in response to that. The first is that it is reclassification. We can see that reclassification has consequences.
Right.
But reclassification itself is not a direct consequence of a marginal non-attainment designation, which is what we're talking about in this rule. The only legal consequence to impose upon Texas of a marginal non-attainment designation is that Texas must submit a SIP revision. And that SIP revision must do 2 things. It must inventory current emissions, and it must impose new source review requirements, which are just meant to prevent further deterioration of air quality. So there's no measure that Texas would have been required to take between the effective date and the attainment date that would have made a difference in whether the non-attainment area was in attainment as of the attainment date.
But the statute has a pretty precise calendar to it, right? And it's, in a sense, there's a doomsday machine that's turned on when there's a marginal non-attainment designation. A couple of things happen. You get the attainment date 3 years out, and then you attain or not, and if you don't, there are consequences.
That is true, Your Honor. I think as an initial matter, it is really important to note here that the Clean Air Act does not contemplate this exact situation where an original designation is remanded, and on remand, EPA determines that that original designation is erroneous, and EPA has been in the situation where it's trying to figure out the best thing to do with respect to El Paso and the other 10 areas that were remanded, and given the fact that there already is a valid non-attainment area in place. So I think that is an initial starting point, but I think also what's an important point to make in answering your question is looking at like broadly how non-attainment areas for ozone are designated. So ozone, for other NAAQS, EPA will designate an area as attainment or non-attainment. For ozone, the Clean Air Act goes further and designates areas into specific classifications based on their level of non-attainment.
There's 5 or 6 different.
Right. The marginal non-attainment designation, those are areas that are the closest to attainment. And really, when you look at the requirements imposed upon states with marginal non-attainment areas, the point of the marginal non-attainment area is really a holding pattern in a lot of ways. It's meant to ensure there is not further deterioration of air quality, but it's not meant to give the state, or it does not impose requirements that the state take to make air quality better.
Wait, so maybe not from the status of having been designated marginal non-attainment, but there are consequences if they miss the attainment, if they don't achieve attainment by the attainment date. They get downgraded to a level, I forget what it, moderate or something, which does trigger a lot of burdens, regulatory burdens.
Certainly, but that has not occurred yet, right? I think the point that I was trying to make. But it could. It could, but only after one, EPA makes a determination that the state was not in attainment as of the attainment date, which has not yet occurred.
But it's not discretionary, right? You can't just say, oh, this might be unfair, so we're just not going to make that determination.
It is not discretionary, but it is a finding that EPA has to make. But also, although it's not discretionary, there are intervening events that could result in the area not being reclassified, even if it is non-attainment. And one of those is this 179B demonstration.
Right, so put that to one side. I know that that's a complicating feature here, the 179B demonstration. And we can get into whether there's some collateral thing that nobody saw on the horizon that then comes in and says it doesn't matter because you're still in attainment. It has to be the case that an area is worse off if they're deemed to be in marginal non-attainment than if they're deemed to be in attainment.
Yeah, so an area is worse off, or a state? So,
well, a state who has an area that's deemed to be, is that not true?
Worse off in that there are requirements imposed upon the state. And those requirements are that the state submit a SIP revision, and the SIP revision, again, inventories current emission.
Right, but if they're in attainment, they don't have to do the SIP revision.
They don't have to do a SIP revision if they're in attainment. But and that I think is important.
So then I guess where I'm going is, if the area is deemed to be in non-attainment, as opposed to deemed to be in attainment as of the past attainment deadline, then requirements kick in that they wouldn't have otherwise faced. And if the attainment deadline had been put 3 years in the future, they might have been able to avoid ever having those requirements imposed on them because they could come into attainment by the attainment deadline.
So So just backing up to make sure I'm not exactly sure I am understanding, but I think, so the first point I want to make is that, yes, there are consequences of a state being designated as a marginal non-attainment area. Those consequences are SIP revision, and EPA gave Texas additional time to submit its SIP revision. Now, in the world, I think this is what your question is getting at if EPA were to reclassify the Doña Ana non-attainment area as moderate, Texas wouldn't have had an opportunity to try to attain by the attainment date. I think that is not a primary retroactivity issue. I think that is a secondary retroactivity issue, and that is because the Clean Air Act would not have required Texas to take any action between the effective date and the attainment date that would impact whether the state is in attainment as of the attainment date. And so, Texas's argument that it could have imposed measures really boils down to a contention that its expectations were upset.
It wouldn't have required actions during that 3-year runway, but there would have been consequences if Texas didn't meet the attainment date, right?
If EPA
You get downgraded to moderate non-attainment.
Certainly, Your Honor, but that is not in and of itself a direct consequence of the marginal non-attainment designation, because it does not happen as a matter of course when an area is designated as a marginal non-attainment area. It only happens reclassification
if you don't do whatever you have to do to attain.
Not quite, Your Honor, because if there aren't any steps.
Putting aside these quirky defenses about foreign pollution or extraordinary events, right?
If the state had not, if during this 3-year period, the state had not taken any voluntary actions to attain, but I think the point that I'm trying to make is that a marginal non-attainment designation does not require the state to have taken any action.
Right, let me try it this way. When you're designated marginal non-attainment, 2 things happen. One is what you're calling a requirement, which is you have to submit a SIP.
Mm-hmm.
Okay, and you took care of that issue by extending the deadline. But a second thing that happens, you're saying it's not a requirement, but I'll call it an exposure, which is as a result of that designation, if you don't clean things up within 3 years, a bunch of other things will happen, right? And it may or may not, but it's a present exposure. It's baked into the legal situation. Right there it is.
Yes, and I think that really gets to, so generally agencies change rules all the time that impact a party's past conduct, in that maybe the parties would have acted differently if the law had been differently in the past. And I actually think this situation is akin to the Treasure State Resource Industrial Association case. In that case, this court upheld EPA's practice of designating an area based on pollution data that was collected before EPA made the NAAQS more stringent, and thus before the industry groups knew that they would have to abide with these more stringent NAAQS. And I think the arguments the petitioners are making here are very similar to the types of arguments the petitioners made there, which is that here Texas could have been able to act differently if EPA properly designated the El Paso as part of the Doña Ana non-attainment area in the first place. Go ahead, finish. I was just going to say, the mere fact that Texas could have acted differently does not render this rule retroactive, because nothing about the marginal non-attainment designation itself required Texas to take any action.
I may be misremembering, or may have misread it, but my recollection is that was just a case in which what was challenged was there was an attainment designation made at a particular time, and it had legal effect going forward. And the retroactivity argument was, well, yes, but it's based on data from the past.
Yeah, but
that seems very different from what's going on here, which is the statutory scheme is you have the designation, it triggers this 3-year, what I'm calling a present exposure. Maybe Texas is calling it a procedural right to clean up over 3 years, right? And that that is vitiated here where you backdate, you issue the new order and don't give them any of that 3-year period?
Your Honor, I don't actually think it's that different in terms of the types of arguments that Texas is making here, because the whole point is pressure.
It's not just use of old data. It's actually
Certainly
backdating I get the term, the designation date.
Right, the effective date.
Yeah, it's very different.
But the arguments that petitioners were making there, which is the argument that Texas is making here, is that they could have taken action. If they had known that the NACs were going to become more stringent, they could have taken action in the past that might have impacted what their classification was when the EPA classified them. And I'm just comparing that to the argument that Texas is making here, which is that if EPA had properly designated El Paso in the first instance, there might have been steps that they could have taken before the area that would have impacted whether the Doña Ana non-attainment area was in attainment as of the attainment date. And in both situations, I think we believe that that type of an argument is really a secondary retroactivity argument, in that what the parties are arguing in both cases is that their expectations about what the law is and what the law would be has been upset by the agency's action. And in the instance of secondary retroactivity, a rule is only invalid if it is arbitrary and capricious.
But are you, I think I get the terminology confused between marginal and moderate. So, yeah. But marginal is the lowest one.
Marginal.
And moderate's one step up. Mm-hmm. Okay, so what's at stake here is the attainment deadline was set before the date that EPA promulgated the instrument that's under review. That's what happened, right? EPA promulgates the non-attainment designation, or it folds El Paso into Las Cruces, and it makes it one area. Mm-hmm. And then Texas never knew that that was a possibility because El Paso previously was deemed to be attainment area. Now it's part of a non-attainment, right?
Correct. That's Texas's argument. Yes.
No, that's just a fact. That's what happened.
The fact that they never knew this was a possibility is yes, the premise for their retroactivity argument.
Right. And then at the same time that EPA makes that move, which is a move, it's different. It changed the state of the universe. It also said the attainment deadline has already passed, right? And then the point is, if the attainment deadline had yet to pass, then the affected entity could take actions to come into attainment by the time of the deadline. Whereas now, that's just off the table because the attainment deadline has already passed. That's just true. That's just fact. The legal consequence of that may be open to debate, but that all is, I think, just fact.
Yeah, I think so. With one caveat, which is that I think I would just like to reframe what EPA did here, because I understand that looking at this narrowly from Texas's perspective, it looks like what EPA did was set an attainment date in the past. But what EPA was trying to do here.
Yeah.
Okay.
I don't mean to cut you off, and I didn't mean to suggest that what you're about to say is obvious. I think I understand that it's a complicated situation because of the remand. And
because there was already a validly designated Doña Ana non-attainment area that El Paso contributes to, which is not a fact that Texas takes issue with.
Right. And so I understand the rationale for folding El Paso into the area that already existed, because you want to keep all that as one sacrosanct area. So I get that it creates a complication in terms of the attainment deadline, because that attainment deadline already was in place for the area as it was previously defined.
Right.
Yeah. And then EPA has to make a determination of what to do now that there's a remand to figure out the El Paso piece of it.
Right.
Yeah, I understand that. I guess the point still holds, though, that from Texas's perspective, El Paso, until that point, had been in attainment. And then Texas is told, oh, actually, it's part of a marginal non-attainment area. And the attainment deadline has already passed. And whereas EPA could have done it so that the attainment deadline is off into the future, it could have. It could have done it for the whole area, for example. It could have. I mean, I don't think there's any law that would have prevented it.
Well, I do think that in revising the boundary, EPA didn't see changing the effective date and the attainment date as being a viable option. So the Cleaner Act.
But would it have been unlawful to do it? I mean, is there some statutory prohibition against saying, because of all the equities at stake, we redefine the boundaries and we're just going to give that area, the entire area, an additional 3 years?
Well, there are very limited instances where EPA can change an attainment date. EPA can give extensions 1 year, but only if certain requirements have been met. And I think, and it's EPA's perspective that it would have been acting in excess of its statutory authority to have used this court's remand to change the attainment date for the entire non-attainment area in a manner in which it couldn't have done absent this court's
Okay,
remand.
so then it could, I haven't thought through that, and that may be right, but then it could have at least done what Texas suggests, which is treat El Paso as its own area and give it. Now, that may be, I can understand the programmatic reasons why that's suboptimal. I get that. But I'm just saying, as a matter of law, I'm not sure of a reason why EPA couldn't do that. Is that barred by the statute?
So the Clean Act does not explicitly state that a contributing area cannot be designated as a separate non-attainment, as a non-attainment area separate from the violating monitor contributes to. But EPA does believe that that creates an unworkable statutory scheme in a lot of ways. And I can provide Your Honor with 2 examples. So for the reclassification.
So let's just say, I'll accept that. I'll accept that it's unworkable from EPA's perspective, because I'm just trying to get to the retroactivity. But I take the point that there may be some serious workability issues there. So, but at the end of the day, the fact remains that Texas is dealing with El Paso, which until then had been in attainment and is now part of a non-attainment area. And the attainment deadline has already passed. That's just a fact, right?
Yes.
So why, whether we think of that as secondary retroactivity or primary retroactivity, I thought part of your submission was there's not even a retroactivity problem, because actually we haven't determined yet whether El Paso was in attainment as of the already passed attainment deadline.
The point that we were making, the point that we were trying to make is that this is not a primary retroactivity issue because there are no new legal duties imposed upon Texas associated with the attainment date. And that even if we accept that this upset Texas's expectations, this is not a secondarily retroactive issue because it's not arbitrary and capricious. I think the point
even if EPA finds that there was non-attainment as of the already passed attainment deadline.
Yes, even if EPA finds the area is a non-attainment, the rule itself is not retroactive because that finding of non-attainment as of the attainment date is not a direct consequence of a marginal non-attainment designation.
How is it not?
Because
the setting of the original designation sets the attainment date and triggers an obligation for EPA to adjudicate the area attained.
Certainly, but reclassification itself and the consequences that flow from reclassification are by no means a certain consequence of just the fact that EPA has to make an attainment determination as of the attainment date. And I think that's particularly true in a case like this, where it's not just that EPA hasn't yet made the attainment determination, but there are some serious factual issues here that could result in the area not being reclassified, even if it remains a non-attainment.
Because of the demonstration project?
Because of the 179B demonstration that's been submitted by Texas and New Mexico. And frankly, that's a big reason why EPA has not yet made an attainment determination, because it is determined it appropriate to give due consideration to Texas's 179B demonstration before determining whether the area is in attainment as of the attainment date.
That's the foreign pollution issue.
Exactly.
But that's just a variation on the chief's original point that, maybe they'll ultimately be judged to be in attainment.
Right. And correct.
Okay. I just have one question on the redesignation.
Yes.
So why isn't it a redesignation if the statute works in the way that Texas says it does, and that's the only statutorily available way to to reach a non-attainment resolution of something that was previously determined to be attainment?
We believe that it was not appropriate for EPA to use its redesignation authority here for two reasons. The first is that EPA uses its redesignation authority when there's already a valid ozone designation, and EPA is presented with new data or new modeling showing that designation should be altered in some manner. Here, there is no valid designation. This court remanded the designation to EPA and said that EPA treated the remand as a concession that EPA's explanations in support of the designation fall short of the Clean Air Act's.
So the load-bearing weight is on the word valid because there was a designation. You're just saying.
Yeah, there's no pre-existing valid designation, and on remand, EPA looked at the same data that was before it when it made that original designation determination. And the second point I'd like to make is that EPA did not feel that it was appropriate to use its redesignation authority because this was remanded to the EPA from this court. And a remand is generally an opportunity for an agency to reconsider the original action that was before the court. The original action that was before the court was Section 107D designation, not a Section 107, I guess it's also D, but D3 redesignation. And so if EPA did not feel it would have been appropriate to use this court's remand to take a completely different regulatory action.
What if you have a situation in which the EPA has reached a designation and has announced it, and then later on they think, oh boy, I'm looking at the same data again. I realize we put a plus in the minus column, and it turns out it should have been designated all along as non-attainment, even though we said attainment. Then what you would have is an invalid designation. Would then that mean that EPA would use the redesignation power to redesignate it, or would EPA then say, oh, we're just going to redo the original designation because the mistake was in the past based on the record that we already used?
Yeah, there is, I believe in Section 110K, there is a mechanism for EPA to fix mistakes, but EPA did not rely on that here, again, because EPA thought it was appropriate to look at the action that was before the Clean Wisconsin Court and reconsider that action and revise the boundary using that exact same authority that was at issue before the court in Clean Wisconsin.
Last question I have, and then we'll let you sit down. Does EPA have an objection? There may be other problems with this, but would EPA have an objection to us holding the retroactivity claim pending determination either through the demonstration project or anything else, including whatever ultimate designation decision is made by EPA on whether there's attainment or non-attainment?
EPA would not have a problem with the court taking that approach, but we do not feel that it's necessary here because we feel that the rule is not retroactive.
Okay,
thank you so much.
Thank you. Mr. Back.
May it please the court, David Bach on behalf of the environmental interveners in support of EPA. I represented the El Paso groups that intervened, that were petitioners in Clean Wisconsin. And I'm also a native from El Paso, so happy to answer any questions about that. I wanted to use my time to answer two questions, one that Judge Katsas asked and one that you asked Chief Judge Srinivasan. Judge Katsas, you were asking about this issue of the exposure.
Right.
And I would say that the exposure always exists for every state at all times. We all agree, I think, that regulation is not retroactive just because it uses antecedent facts. That's the Landgraf case. And the Clean Air Act is a remedial statute. It's designed to look at the antecedent facts of an area, see what the air quality is, and then impose the classification that's correct based on the seriousness of the problem. So actually, in the Sierra Club versus Whitman case that Texas relies upon, it's not part of the holding at all, but it's just a background fact that area was designated as a moderate non-attainment area. Same concerns that Texas is concerned about. based on data from 1987 to 1989.
There would be no retroactivity problem whatsoever if Congress looks at an area and says it's really polluted as a result of past conduct, and from enactment date forward imposes onerous cleanup restrictions on the area, right? That's fine. And I think you're analogizing to that.
Well,
but what we have here is just a different scheme, right? The liability is not imposed from promulgation date forward based on someone assessing what happened in the past. It's imposed under this scheme where the agency is supposed to do something, and and that act creates a 3-year period, which creates an obligation to adjudicate attainment and triggers consequences from that point forward.
well, so Your Honor,
And in that scheme, they choose to backdate the attainment, backdate the designation date and therefore the attainment date.
well, so Your Honor, I think that it's not just a question of Congress specifying this. I think this is how the Act works in general, that anytime EPA makes a designation, after promulgating an Act, it looks at data for the areas around the country that already exist, predating that Act. And so the Treasure State case is one example where it was a 2010 sulfur dioxide max, and EPA used data from 2009, predating that rule before anyone knew that they might be subject to this limit.
To prospectively change a designation.
But the consequences that were imposed could have been the exact same. They could have been designated as a moderate area. I think that's one very important point to get across. There's no entitlement to start at marginal. EPA has the discretion if it's appropriate in EPA's determination, it can start an area as initially designated as moderate. In fact, we argue in our brief, it could have done that. It could have done so here, because I think there's a very important equitable point to make here, which is that my clients have been living with excessive air pollution since 2016, and Texas has been fighting to delay. Texas initially recommended a non-attainment designation, so there's been an awareness of this problem for quite a long time. So I don't think the Treasure State case is that different. The Weld Guardians case that the chief judge also authored, in that case, EPA retained a fast approaching attainment deadline. The deadline was December 2015, and the states only had a year to prepare for that. So they were going to be judged based on 2 years that had already happened at that point. So again, it's looking at antecedent facts, but the Clean Air Act is a remedial statute. You're supposed to look at antecedent facts. There's no procedural right to 3 years under the Act. In fact, the statute actually says, Section 7511A says the attainment date shall be as expeditiously as practicable, but not later than, and in this case, 3 years. So I think in Texas's brief, it actually slips up and it says it should be at least 3 years. So that's exactly the opposite of what the statute says. It says as expeditiously as practicable, but in no case later than 3 years. And that brings me to the second question I wanted to briefly answer from the chief judge about whether EPA could have simply extended the attainment deadline for the entire combined area. And Your Honor actually wrote an opinion that NRDC versus EPA 777 F.3rd 456 holding exactly that they cannot do that. The statute does not allow EPA to push back attainment dates. And we would also argue that the statute would not have allowed EPA to designate El Paso as a separate area. If you actually look at Table 1, it says the area shall be designated based on the design value of the area. And then the table lists marginal as being, in this case, 71 parts per billion to 81 parts per billion. There's nothing in the scheme that contemplates designating a contributing county separately from the underlying area that's violating.
I think NRDC case for me was, I think, early in my career, so it's a long time ago.
There's a lot of NRDC versus EPA cases too.
But to me, the authority of the agency to do something stems in part from the fact of a remand. I think the nature of the beast here is that when there's a remand, Wild Earth exemplifies this. There's often situations in which the agency has to figure out how to accommodate a bunch of things that point in various directions in a complicated regulatory scheme. And it may well be that when there's a remand to revisit something, that gives some license to the agency to fashion something that in the first instance the statute might not have contemplated. And that's what, to me, gives the agency some power in this kind of circumstance, potentially. I don't know this, but gives the agency some kind of power to fashion a resolution that best accommodates a bunch of different provisions that all don't contemplate the possibility of remand for one geographic area that's bound up in another geographic area, and we have to figure out how to reconcile.
I think Your Honor's point is exactly correct. This is a complicated situation that's not contemplated at all in the statute. It's similar to the Wild Earth Guardians case. And it also relates to another point I would like to make is that Texas could not demonstrate reasonable reliance on this. The Treasure State case says that reasonable reliance needs to be shown. Texas has been involved in this process from the very beginning. They were parties to Clean Wisconsin. They saw that the El Paso designation was so clearly unlawful that EPA could not even defend it in this court. That was many years ago. So the idea that they were, completely caught off guard. In fact,
but our remand decision also said that that the designation might well be maintained.
It did say that.
So it wasn't obvious that the result was going to be non-attainable.
Those of us who follow the case closely, in fact, Texas itself in 2016 initially recommended a non-attainment designation for El Paso.
But then they recommended attainment.
They did. But I think that the idea that they were completely caught off guard by the fact this might have happened is just not credible. So I certainly appreciate the time, but I do think, like I said, I think it's really important that this is a situation that just is not contemplated by the act. But there would have been problems with the proposals that Texas has put forward, and you might have seen us as petitioners in that case. And I think that's the reason why it's so important to defer to the agency when it deals with a complicated situation like this, is because it realizes that it's going to be, it could be sued no matter what it does. And you have to give the agency discretion to reasonably resolve competing concerns, including, as I mentioned, significant public health impacts in our area, where every other part of the country has had these controls, in place since 2018. We still won't have them, and we're looking at maybe 3 more years, which I don't think is what Congress contemplated when it passed the Clean Air Act.
Thank you, counsel. Make sure my colleagues don't have questions for you. Thank you, Mr. Bauer.
Thank you, Your Honor. Thank you, Your Honor.
Mr. Davis, we'll give you 2 minutes for rebuttal.
Thank you. And if I could just start with a bigger picture point. The Clean Air Act is about achieving clean air, but Congress doesn't pursue that objective at all costs. It provides important procedural protections to states what attainment dates are all about, allowing states to have a chance to reach attainment. And this retroactive approach here just cuts the states out of that. And the fact that the states weren't required to do anything doesn't mean that they couldn't have done anything after that non-attainment designation. And in the implementation rule for this MAX, EPA explained that states in the position of having a designation like this could impose additional controls or could seek voluntary redesignation. There are things states can do that, when EPA regulates retroactively this way, are off the table. The Treasure State case just doesn't apply here, because there it was just looking to pass data to do something prospectively. As I think Judge Katsas, you may have suggested, that's consistent with Justice Scalia's vote.
You agree with my recollection of what that case
That's
is?
right. That's right. And Chief Judge Srinivasan, the Wild Earth Guardians case, I mean, we saw at least 3 times in that opinion the court talking about the novel circumstances. Thus, that's an indication that that can't be applied outside of those circumstances. And I've already mentioned one distinguishing factor. The other is that the court noted that EPA there avoided relying on the counterfactual assumption that subpart 4 of the statute applied all along. But here, EPA has embraced the counterfactual assumption that El Paso was always a part of the settlement part area. My friend on the other side mentioned section 110K. That's a SIP provision. 7410K provides correction authority that just doesn't apply here. We're not talking about SIPs. And I guess the final thing I would say, I see my time has expired, is this court's decision in the Utility Air Regulatory Group that went up to the Supreme Court in 2014 made the point that an agency may not rewrite clear statutory terms to suit its own sense of how a statute should operate. And it went on to quote then Judge Kavanaugh's dissenting opinion from the denial of rehearing. And in our view, that's what should guide the analysis here. I think Mr. Bach is correct that EPA gets sued by all kinds of different sides all the time. Guiding principle should be, what does the statute say the agency may and may not do?
Thank you, Mr. Davis. Thank you to all counsel. We'll now shift to the arguments in 21-1263. Mr. Schenkman, please proceed when you're ready.
Thank you, Your Honor. May it please the court, Ethan Schenkman for Petitioner Weld County. At council table is John Jacobs, also for Weld County. I'd like to reserve 2 minutes for rebuttal. Your Honors, EPA's decision to freeze the record on remand on the Weld County issue as of the record that existed as of April 2018, and to disregard all new evidence, no matter how probative, no matter how relevant, was arbitrary and capricious for at least 4 reasons. First, Colorado and Weld County were denied the opportunity to introduce the most recent data that was available at the time that they received a 120-day notice letter from EPA, which first advised them that EPA was going to disagree with the designations that Colorado itself had proposed. The first time around this proceeding, which was reviewed in Clean Wisconsin, states that received their 120 notice date letter in December 2017 were permitted to respond with either 2014 through 2016 data, or if they had early certified data, they could also submit 2017 data. They were permitted to submit, in response to EPA's notice, the most recent data that existed as of that time. Here, EPA did not first notify Colorado and Weld County that it was going to depart from Colorado's recommended designations until the remand, specifically until May 2021. And Weld County was permitted to comment on that new 180-degree different decision, but they were told the record's closed. We're only going to look at evidence that was submitted as of April 2018. We are not going to even comment on, let alone consider, any new evidence that existed as of May 2021. Therefore, depriving Colorado and Weld County of the opportunity that every other state, every other area in the country was provided. And we think it's arbitrary and capricious for that reason.
Is there any reason to think this would have made a difference? You say under the current data, the percentages contributed by Northern Weld County seem relatively low, 4%. NOx, 2.6% of volatile organic compounds. Do we have any sense what those numbers would have been under the older data?
They were higher under the older data, but Your Honor, yes, that's actually my second point, which is that this would have made a huge difference to the decision. So I'd like to address your question directly, but to start by saying that EPA admits that based on the old record, the record that closed as of April 2018, quote, it does not have an accurate understanding of actual emissions from the northern portion of Weld County. That's at Joint Appendix 779. During the remand, Colorado commissioned and Weld County submitted new modeling, source apportionment modeling that for the first time in this whole proceeding allowed EPA to isolate the contribution from Northern Weld and Northern Larimer counties. The data, Your Honor, Judge Katsas, that you reference is just emissions. Emissions
it's
is
just-
it's just emissions from sources. That's only one factor. You also have to take into account the air quality data, the meteorology, the geography, the topography. This source apportionment modeling that was introduced into the record by Weld County and commissioned by the state takes all of those factors together, synthesizes them, and then isolates the contribution from a particular area. It showed that northern Weld and northern Larimer counties together contribute 0.4%, 0.4% of in-state contributions of ozone at the most problematic monitor, which was NRO. That's compared with within the rest of the non-attainment area, 88%. 0.4% compared with 88%. The other adjacent attainment areas, the attainment area to the west, contributed 8.3%, and the adjacent attainment area to the east, 3.2%. Northern Weld and northern Larimer County, again, 0.4%. Highly significant. It was not only are those numbers truly remarkable in terms of showing the very small relative contribution of northern Larimer, northern Weld counties, but it filled the exact gap in the record that EPA itself recognized. That's my second reason for why it was arbitrary and capricious to completely disregard all new data. Third, this court's opinion in Clean Wisconsin expressly recognized that if there were to be a remand, that the remand could result in the submission of new or updated evidence. That's at page 1175 of the court's opinion. So this notion that EPA has that the court made us do it, it was the nature of the remand, the court somehow didn't expect us to take any new information into the record on remand, I think is belied by the wording of the opinion itself. And the reference to the remand having to be done as expeditiously as practical, that's a term that comes from the Clean Air Act that references a 2-year deadline with the possibility of another year extension. There's no evidence in the record whatsoever that there would have been severe delay if EPA had considered the data that had been handed to it and that was sitting there in the record in this case, if it had been required to do so. And fourth, Your Honor, I think it's critical that we look at the reasons that EPA itself gives for freezing the record as of April 2018. That's what this court needs to judge EPA's decision on, and not on the post hoc rationalization, by counsel. Yes.
To what extent do you have a higher burden insofar as you're asking EPA to divide up a jurisdictional Weld County? Why isn't it enough for them just to say, we're going to look at these things by counties? And it's one thing if you tell us that Weld is different from Larimer, but we just don't want to be any more granular. We will divide up areas as the state has seen fit its purposes and follow their jurisdictional bounds.
Sometimes it does that, and sometimes it divides counties. It depends on the facts and by factors. The Weld County, the non-attainment boundary for Weld County has been divided between South and North Weld County since I think the late 1990s. This was the first time that EPA had changed that boundary to include the northern area of Weld County. Now, Your Honor, but stepping back for a second, looking at this court's precedents, because that's EPA's main rationale, is that Mississippi cites to the Mississippi Commission case. So I'd like to talk about. But we have to step back for a second that this court in Catawba said that our precedents require EPA to use the best information available in making its designations. That's the general principle. Mississippi Commission said that if EPA decides not to use more recent data that are available, that it must adequately explain why. Okay. Mississippi Commission was a completely different case. That was a case about mismatched data sets. There's no mismatched data sets in this case. Mississippi Commission, the task at hand in Mississippi Commission was to draw the entire non-attainment boundary of a tri-state area that involved Tennessee, Arkansas, and Mississippi. EPA had more recent data from 2 of the states, but not from 1 of the states. And so EPA's explanation for why it then instead used the older data set that would be complete for all 3 states was that it didn't want to mix and match data sets for the task at hand, for drawing the whole boundary. In this case, the only task at hand was Weld County, 1 out of 9 counties. That's the only thing that this court remanded. For purposes of just determining the Weld County boundary, EPA had a full and complete and verified data set from 2018 to 2020. It wouldn't have to, there was nothing mismatched about it. It's a completely different situation. There's other distinctions for Mississippi Commission too. That wasn't a remand case. And the data there, it was only a 1-year difference, whereas here the data were 5 years old by the time EPA sent its first notice letter. EPA says that if it had been required to use the new data, that might have led to inconsistent results. But there's zero explanation in the record as to what those inconsistent results might have been.
I'd just ask you, I know your time's up, but I want to ask you
Yes,
the
sir.
following question. You mentioned that it's important to draw a distinction between what the rationale EPA gave in the instrument under review and the rationale, post hoc rationale of council.
Yes.
What's the delta? What are you specifically concerned about that was added?
There's a number of things, but for one thing, Your Honor, with respect to the new source apportionment data that for the first time enabled EPA to isolate contribution from Northern Weld County that ability didn't exist before. In its briefing, DOJ and EPA suggest that there might have been some issues with that modeling, but that's raised for the first time in their brief, in the record, in the decision. EPA doesn't even acknowledge that data exists. It doesn't doesn't take issue with its validity, with any technical aspect of the modeling, nor does it take issue with the significance of that data. If I could just close this part of my argument with just one last point, which to sort of sum it up, on EPA's theory, even if Weld County has a handful of sources that are major sources, even if those sources had closed during the remand period and there were now 0 emissions, EPA's theory is, sorry, the record was closed as of April 2018. Even though we gave every other area of the country the opportunity to put in the most recent evidence, we're not going to give you that opportunity. And I think that illustrates why that was an arbitrary and capricious decision. Thank you.
Thank you, Mr. Shankman. Mr. Higgins?
Good afternoon, and may it please the court. I am Elliot Higgins from the Department of Justice representing EPA. I will be arguing in response to Petitioner Weld County. I will be splitting my time with interveners in support of the Weld designation. I have 8 minutes, interveners have 2. In 2018, EPA concluded that Northern Weld County did not contribute to nearby violations of the 2015 ozone NAAQS and therefore designated the area as being in attainment of those NAAQS. This court remanded that designation, observing, among other things, that Weld County sources generate exceptionally high amounts of VOCs and NOx. On remand, EPA reevaluated the extensive technical record before it at the time of the 2018 designation and concluded that emissions in Northern Weld County did in fact contribute to nearby NAAQS violations. EPA therefore revised its designation of Northern Weld County as being in non-attainment. In reaching this highly technical designation, EPA observed that Weld County's NOx and VOC emissions dwarf those of all other counties in EPA's area of analysis. Indeed, Weld County alone emitted more than half of the Denver Metro's total VOC emissions and 1/4 of its total NOx emissions. Much of these emissions result from oil and gas activities, which are present in both northern and southern Weld County. Furthermore, EPA's meteorology and topography analyses show that the Denver Basin influences meteorology to trap emissions from northern Weld County and produce ozone in the Denver metro non-attainment area.
Before you dive into the 5 factors, can I just ask you about the threshold question of which data to use? That seems it seems a little troubling. If the case goes back on remand, and the agency has with a remand without vacatur because the original attainment designation was not adequately explained. You're back on remand, you have one of 2 choices. You can either try to embellish the explanation in order to defend the designation that had been made some years in the past, or you could take new agency action to change an attainment designation into a non-attainment designation. And you chose the latter, which is fine, but it still sort of requires new agency action that by definition has to take place some years later. And that just seems very different from Mississippi Commission.
Well, Your Honor, it was reasonable for the agency to rely on the existing technical record for at least 3 reasons. First, reliance on the existing data maintains consistency within Weld County, within the 9-county Denver metropolitan area, and across the country. Second, the reliance on existing data is in keeping with this court's precedents, including the Mississippi Commission case that you referenced, in which this court concluded that EPA reasonably declined to consider newer data in favor of a matched data set. And the third reason—
when they're making all these designations at once, and they have data flowing in from different years, some are certified, some are not. Just, here's the agency action designating everything countrywide. We're just going to use the same set.
Well, Your Honor, EPA was not reevaluating Weld County in a vacuum. EPA had 10 other designations on remand from the Clean Wisconsin case. So it had to make this decision across the entire country. And in light of this court's unusual step to set the time dimension on remand, it required the agency to act as expeditiously as practicable, which was not a small point in the Clean Wisconsin case. There was supplemental briefing on this issue with various entities arguing that the agency was not acting quickly enough. EPA decided to rely on the existing technical record. And that's a highly technical decision that—
Does that take you to the point that was referenced by your colleague on the other side, that if the sources had shut down in the relevant area and the emissions were 0, that it still wouldn't have been non-arbitrary and capricious to rely on the old data set?
Your Honor, I'm not familiar with that particular point in the other case, but what I can say is— it was—
Oh, not in the other case. I'm just referencing the argument that was just made, that the upshot of EPA's decision to use the pre-existing data rather than take into account subsequent developments would be that even if in that intervening period the sources had all shut down and there were 0 emissions at this point, still would be judging it based on data that had not taken that into account. The agency would take the position that that's okay to do, that that's not arbitrary and capricious.
Yes, Your Honor, that's correct. And if that was the case, and if all the sources shut down in northern Weld County, the Weld County would not be without remedy. They could petition the agency for redesignation in light of newer data that shows that Weld County should no longer be a non-attainment area. So the county is not without remedy if it thinks that this new data shows that Weld County is in attainment. However, that's an entirely speculative proposition. EPA has not looked at that new data and made a determination one way or the other whether the new data shows that the northern Weld County is in attainment or not.
And it's also a procedural one that for failure to actually file a petition EPA had no rational basis to consider this new data that showed new things that were quite pertinent, or purportedly showed new things that were quite pertinent.
Judge Rogers, I'm sorry, it's yellow, not red. Your Honor, we had a remand of this particular designation action. So, of the original designation action. So,
I understand that, but I'm not answering either Judge Katsas or Judge Srinivasan's question. That's all I'm getting at. And you said, well, petitioners could have filed a petition.
Right, Your Honor. In the first instance, my point is that EPA's decision to rely on the existing administrative record was a reasonable one under the circumstances in this case where.
Because you say consistently throughout the region.
Right, Your Honor. The agency wanted to ensure that it had a matched data set throughout the Denver Metro non-attainment area. So it wanted to make sure that it was designating northern Weld County using the same data that it used to designate southern Weld County, as well as the rest of the Denver Metro non-attainment area.
And does statute obligate the agency to, or state to examine the situation every 2 years, or is that another provision?
I apologize, Judge Rogers, I didn't quite hear your question.
Is there any statutory obligation to consider changed circumstances periodically?
Yes, Your Honor. Through the classification process, EPA evaluates whether, basically how the Denver non-attainment area is doing. So periodically, EPA evaluates whether the monitors are still violating, what the quality of the air is, and that allows for some reassessment or forward-looking reassessment.
Suppose there were no remand involved. EPA made designation, defined the attainment area not to include northern Weld County. Does they designate northern Weld as attainment? And then 3 years go by and EPA starts rethinking and comes to the conclusion that they should change the attainment area to pull in Weld County. Maybe they should do that, and they're considering that. Could they at that point just refuse to consider current data on that question, just in the interest of, well, we have this Denver area and we've been using 5-year-old data to assess it. So we're going to use old data on this new question, whether to pull northern Weld County in.
Your Honor, I don't precisely know the answer to your question, whether it would use the existing data set or whether it would use new data. That's not something that I've discussed with EPA.
I think the question is not what they actually would do, but if they did use.
Would that be arbitrary?
If in the future EPA decides that northern Weld County needs to be an attainment, or needs to be a non-attainment, and relied solely on the existing data set, and this is 3 years in the future.
Right.
I think it would depend on the facts and circumstances of that case, recognizing that.
What's the scenario in which it would be okay to do that?
Well, I think the agency would want to be careful not to treat areas inconsistently, as that is the hallmark of arbitrary and capricious action. So I think the agency would want to.
So then could the agency then just say that we've treated this large area, which is composed of 17 smaller areas, consistently. So we're not going to entertain any petitions for redesignation as to any sub area, because that would require us to be inconsistent.
Well, I would note, Your Honor, that the petition for reconsideration actually it contemplates the consideration of new data. So it's a separate process than the original designation process, which necessarily requires a matched data set.
And you say necessarily requires, meaning that it's legally required, or meaning that that's just the best way to do business?
That's just the best way to do business. I shouldn't have said necessarily required. But
Yeah, I was just trying to understand what you meant by that.
It's a reasonable choice to rely on a matched data set, which is what the agency decided to do under the circumstances of this case.
Okay.
Thank you.
Thank you, counsel. We'll hear from Mr. Mahar now.
May it please the court, Ryan Mahar on behalf of Boulder County and the other interveners in the Weld County case. I'd like to address 3 quick points. First, EPA has justified its use of the original data set that it used when making its initial designations to now add northern Weld County to the non-attainment area. Weld does not provide any authority requiring EPA to consider Weld's new data. Second, even if the court did consider new data, which it should not, the new data would actually compel EPA to reach its same conclusion, contrary to Weld's assertions. That's because Weld County now contains an air quality monitor that shows a violation of the ozone standard in the county itself for the most recent data period of 2019 to 2021.
In northern or southern?
That's in southern Weld County, Your Honor, but there is not a monitor in northern Weld County. The monitor that displays a violation is only 23 miles south of the arbitrary line that divides northern and southern Weld County, while ozone pollution can travel hundreds of miles. EPA typically considers the whole county to be in non-attainment if it contains a violating monitor. That's unless there's a significant geographical feature like a mountain range that would intervene to prevent pollution from traveling throughout the county and causing harm throughout the county. There is no such landscape feature here. That was partially litigated in clean Wisconsin. Practically speaking, EPA would be doubly compelled to reach the same conclusion if this matter were remanded, because Weld County both contributes to violations in other counties and now itself contains a violating monitor. I'd quickly like to point out that recent data also contradicts Weld's claim that oil and gas emissions have gone down significantly since 2011. Even if emissions were going down, which is not the case, the Clean Air Act is concerned with attainment of the standards, and we've seen that Colorado has repeatedly failed to attain those standards. This court should deny the petition. Thank you.
Thank you, counsel. Mr. Shakeman, we'll give you the 2 minutes for rebuttal that you asked for.
Thank you, Your Honor. 2 quick points in response to interveners. First, their argument that the more recent data as of May 2021 would not have made a difference. That's a perfect example of post hoc rationalization. EPA does not state that as a rationale, does not reach that conclusion, does not even evaluate. Second, interveners
Can't the lawyers defend on harmless error grounds?
they can defend on.
I'm not sure that
this
counts as a post hoc rationalization.
No, the argument that it literally would not have made a difference is a technical argument that needs to be something that EPA has concluded on the record. But in any event, and I want to give the citations for the record, Joint Appendix 1149 and Joint Appendix 1158 are where the source apportionment modeling is that shows what northern Weld County and northern Weld County only contribute 0.4% in state ozone. So there's no possibility that this could be a harmless error. Also, interveners cite to this argument they make about a new monitor in Weld County. That's based on data that even postdates May 2021 and is not in the administrative record that is before this court. So it should be completely disregarded. Now, in response to my friend from Department of Justice, he brought up on the consistency point. He brought up the fact that with respect to the other 14 counties that had been remanded, EPA also limited its consideration to the old record. So we want to be consistent. But Your Honor, this proves our point. For all of those other 14 counties, EPA either affirmed the state's original proposals, so no problem, they can stick with the old record, or they had already given the states in those cases before the first time around their 120-day notice letter. So those states in those cases had been given the opportunity to put in the most recent data available as of the time they received notice from EPA that EPA was going to disagree with the state's recommendations. And this is, I just want to give you the citation from their decision and the 14 other cases. It's at 86 Federal Register 31442. EPA notes that EPA's December 2017 initial designation and April 2018 final designation, what was at issue in Clean, Wisconsin, aligned at that time with Texas's and Colorado's recommendations for El Paso and Weld counties, respectively. And so at that time, EPA had no need to and did not notify the states that the agency planned to modify the state's recommendations. EPA did that for the first time in May 2021, and the state and Weld County should have been given the opportunity to put in the most recent data available as of that. Thank you, Ron.
Thank you, counsel. Thank you to all counsel. We'll take these cases under submission.